Good morning, everybody. Happy Tuesday. Welcome to TCF Live. My name is Dan Soul. I will guide you through this 3-hour Courtlandia journey. We're going to start with Brian Oakley. A few minutes ago, he engaged in a rather intense conversation with a pro se defendant.
I don't know how many we've got, but I wanted to take care of some pre-trial stuff. So you brought a bunch of paperwork in 2 weeks ago or so? Okay. Most of that I couldn't figure out if you were asking for something, if you just submitted that for the court to have it. The one thing that looked like an ask was you filed a motion basically attacking the Monroe County conviction again. Would you agree?
Yes, I mean, I put that in there.
Okay. Well, we argued that out once, and I told you that whether or not Monroe messed up, I could not overturn what happened at the Monroe District Court. You'd either have to go back to the District Court or the Circuit Court in Monroe County. Remember that? We argued that motion once? All right. Is there anything else that you want to deal with out of those filings or anything else prior to getting the jury in? I can't hear you. Yeah, pull it in. Okay. So you filed a stack of documents a couple weeks ago. Okay. I want to know if there's any of that you want to deal with now, because we're not going to argue motions in front of the jury. Okay. All right. So none of that filing is something you wanted to deal with before the trial. Okay. So you're planning on submitting 240 some pages worth of evidence today? Okay. Understand that all of that's subject to an objection from her if it's not relevant. Okay. All right. And I'm going to tell you right now, all of that stuff from Monroe is not relevant.
Talking about the record.
I'm sorry? The record. The driving. Well, the driving, I'm assuming the people will plan on introducing your driving record. Okay. All right. Okay. So do you have any other pre-trial questions?
Yes. Some was made the evidence to the jury. So,
Okay. Well, I don't know if you will or not, because as you submit something for evidence, we'll have a discussion about whether or not it's relevant, whether or not it's probative versus prejudicial, all those things through the court rules. Understood?
you know, where these very, excuse me.
That's all right. Take your time.
It's all based on the, validity of the judgment. Validity of the judgment.
But it doesn't, and I explained that to you when you filed that motion. The Secretary of State, hold on, let me talk. The date of this arrest, if she can prove, she being the prosecutor, if she can prove that on the day of this stop, your license was suspended from the Secretary of State, the fact that it was improperly suspended by Monroe County doesn't change the fact that the officer had paperwork that said you were suspended from Secretary of State. That's why I told you months ago, you have to attack that judgment in Monroe if you think it's inappropriate. But, and I told you, I can't,
To overturn, just to recognize the jurisdictional defense. We are
but hold on. It doesn't matter if I recognize something. Sir, don't interrupt me. Don't interrupt me. It doesn't matter even if I agree with you that Monroe did something wrong, there's still a valid suspension from the Secretary of State. But you have to deal, but you can't deal with that here. Well, whether or not you can make that argument to them is based on the discussion we have. You want to have that discussion now, we can have it. Well, no. You're not going to present anything to the jury until I tell you you can't. That's the way it works. So let's argue that right now. You want to present your theory of the Monroe case. Interrupt me one more time, sir. We're going to have a long day today. Interrupt me again, and I'm going to hold you in contempt. You understand that? If you want to present to the jury what you claim was wrong in Monroe that led to an improper judgment that went to a Secretary of State suspension, if you want to argue that to the jury, we'll discuss whether or not that should be in front of the jury today right now. Is that your argument? Okay. All right. Is there anything else you want to, I tried to put in my words what you're trying to do. Do you want to put it in your own words so I can give Madam Prosecutor a chance to respond?
And that.
Okay. Madam Pross?
To the courtroom.
Okay, well, that's too vague. That's too vague. That's too vague. Once again, yes or no? You want to talk about what you think was wrong in Monroe to this jury today?
No, I want to talk about the record and how it got there to the jury today.
And how are you, and what is that going to be?
That's going to be the laws of the four rules. The four rules, that's all I present, plan to present, four rules, and the judgments that are based upon the four rules.
Doesn't that get you to a discussion about Monroe County?
It all starts with the record. It all depends on how the record got there. What was that because prosecutor and according to your statement you just made is the record. What he saw when he pulled me over is what he went by when he arrested. Okay.
Well, I can guarantee that's going to be part of the case because this is a drove while license suspended charge. My
Has to be authenticated as to why it is there. How
I disagree with you, sir. I disagree with you, sir. What she's going to have to, what the prosecutor's going to have to present today is a certified record from Secretary of State that shows you were suspended. There's nothing that says we have to get into why you were suspended or how you were suspended. What court rules are you referring to?
2.105.
What's that say?
Individual. Process may be served on a resident or non-resident individual by delivering a summons and a copy of the complaint to the defendant.
All right, Mr. Blade, let me stop you. That court rule is about civil cases, like if you're not paying your credit card bill. That's for civil cases, not for drove while license suspended charges, not for criminal cases. It most certainly is. It's a 93-day misdemeanor. Drove while license suspended, revoked, or denied. That's the top charge on your file. It's a criminal case.
It can be a criminal charge, but
Sir, trust me when I tell you, I can put you in jail on this charge. By definition, that means it's a criminal charge. So we're not talking about civil court rules. Irrelevant. Because that case, or excuse me, that court rule 2.105 is regarding civil process, not criminal. I told you when you said you wanted to have a jury trial by yourself, you were in over your head. We're not talking about 2.105 today. Not in front of the jury. I'm sorry, what? I don't understand what a containment is. Continuance? Absolutely denied. The jury's coming in today for a jury trial. We gave you a scheduling order that gave you plenty of time to file any pretrial motions. I gave you grace today when I talked about what you've brought in 2 weeks ago, because that was a day late. So absolutely no, you are not getting a continuance today. If you want to take 2 or 3 minutes and talk to the prosecutor about seeing if there's any offer, that's fine. Otherwise, we're going to a jury trial without an attorney, because that was your choice, with all 3 charges. I'm sorry, was that a yes to discussion?
Yeah.
Okay, all right, take a few minutes, not a lot, because as soon as I've got enough jurors, I want to get them started if we're going to work them.
Alrighty, friends. Good morning once again. TCF Live. Happy Tuesday. My name is Dan. I will guide you through the next 3 hours. It's good to have you all here. So, again, this was a few minutes ago. Judge Oakley just kind of opening up on fire. I think we've seen this defendant a couple of weeks ago when he insisted on going to trial and he insisted on representing himself. I'm pretty sure this was the same guy. but we'll come back. Apparently they're going to go talk about perhaps a deal, because I think he just realized he's in way over his head, because I remember somebody in front of Oakley insisting that he represent himself, and I'm pretty sure this was the guy. But I'll keep an eye. We'll come back. In the meantime, let's go to the 44th District Magistrate Urich. Say good morning to him.
That's you.
Correct.
Mr. Aldi, you were present just seconds ago when the court explained the nature of an informal hearing. True?
Correct.
So you understood the court's instruction that you must select from one of three options to protect your rights.
Yes, Your Honor.
Thank you very much. Mr. Aldi, the citation before the court was issued May 10 of this year at 8:08 in the evening. You were operating a 2025 Hyundai black in color on 11 Mile Road at or near Coolidge Highway in the city of Berkeley. And at that place and time, it was discovered your vehicle plate had expired on your birthday in January. So this is a simple citation for expired plates. It is 0 points and non-moving. You may admit responsibility. You can admit, explain, and display an updated registration, or you can deny responsibility, and the court will swear the parties and take testimony. What do you wish the court to do?
I admit responsibility of totally forgetting, and I could have swore I put a sticker on my car, but it must have been
Okay.
a lot longer. I did within 10 minutes of the actual ticket getting pulled over, arriving to my house, get everything updated, and I have a proof of all of that.
Okay. You're still a young person. You're not supposed to start forgetting these things quite yet.
I know.
All right. Mr. Aldi, so that date and time you were driving in the city of Berkeley with an expired tag, correct?
Correct.
And you got it taken care of. Do you have your registration handy?
I do.
Could you hold that up to your device? Say your name, please.
Kendra Angaraldi.
I believe the court sees it. Do you see it? PSO Donnelly? Okay. So that's a motion to dismiss.
Yes, Your Honor.
That's what that means. Okay. Happy birthday, Mr. Aldi. You're going to be driving for a good long while. You know what to do next January or the January after that. Okay.
Thank you so much, Your Honor.
Good luck to you.
Thank you. Bye.
Thank the officer.
Thank you, Officer Donnelly.
You're welcome.
I'm being confused again. PSO Larson.
Sorry. Yes, it's Larson, also formerly known as Savage.
Okay. Now we got it. And has anyone heard or seen from Officer Shuey?
Lieutenant Shuey?
Yeah.
D. Shuey? I haven't, but I can text him real quick if you want.
All right. It's not necessary yet. Just sort of taking attendance. Non-mandatory. All right. I got another one of yours. Is it Sergeant Donnelly?
PSO Donnelly, Your Honor.
Okay.
But I'll take Sergeant if you're promoting me.
It could happen at any moment. You don't know. This is case number 26, B like Berkeley, E01954, People versus Kalen Howard. That's you, sir? Okay.
Yes, that is me.
All right, Mr. Howard, find a good, comfortable spot where you might be able to hold fast for a moment. Today is the date and time for your informal hearing. You were here just a moment ago when the court explained that procedure, correct?
Correct.
And so you understood the court's instruction that you must select from one of three options to protect your own rights. True?
True.
Okay. Sir, this citation indicates that on April 22nd of this year at 6:12, so 6 past midnight, you were operating a 2011 Toyota white in color on 12 Mile Road at a Greenfield in the city of Berkeley. And at that place and time, you were cited for violating Michigan's hands-free law, in as much as you were using, touching, or holding a mobile electronic device. The citation suggests operating while watching videos, phone mounted to dash to the right. So you have three options today. You may admit responsibility, you may admit and explain, or you can deny responsibility and the court will swear the parties and take your testimony. What would you like the court to do for you?
Um, I think admit responsibility, but explain.
All right. So you're confirming to the court that on the date in question, you were operating a motor vehicle in the city of Berkeley while using a mobile electronic device, correct?
Yeah.
All right. Court accepts your plea. What's happening, Mr. Howard?
So I work at Target on 12 and Quinder and
Okay.
Warren, and I live in Southfield, by 11 and Inkster. I was just driving home. I originally had my phone up on the little mounted spot with a map to tell me where to go to take the freeway,
Okay.
but I'm pretty sure you probably heard about all the freeway stuff that's going on right now. So I ended up just not taking the freeway. So I closed it out and I just put up a video for sound in the background, just something to hopefully make me laugh because it's that literal day, like a couple days before that was a bit of a rough day. I have the obituary right here. My grandma actually had passed on April 18th.
Oh, I'm sorry.
So appreciate that. It was my first day back to work, and I just needed something to try to cheer me up. So I just put on the video. I wasn't watching it. It wasn't a watch like video. It was really just a guy making jokes while he's playing a game, but the game wasn't important. It was more so about him. I watch him all the time. He's one of my
Okay.
favorite YouTubers. So I was listening to him, just chilling, driving straight shot, straight down 12 Mile, literally from, like I said, 12 in the Quinder all the way down to 12 in Inkster. I turned down Inkster. And that was it. I literally saw everything around me. I wasn't watching the video at all. I saw when the officer was on my right. I saw when he was on my left. I saw him back up. And then when I started going forward, he got behind me. I saw my gym that I passed. Like I saw everything. I was very aware of everything. I was not watching it. I was just listening to it. And I let him know that. But he said it was still a thing. And so yeah, that was
Okay.
what happened.
Just so that we are all on the same education curve, that statute is, not that we all memorize it, Michigan Compiled Law 257.602, which indicates except as otherwise provided, meaning to say exceptions for public safety and emergency technicians, etc. An individual shall not hold or use a mobile electronic device while operating a motor vehicle. So while you didn't appear to be quote unquote holding it at that moment, it was in some form of use. The court would simply suggest this. Court is giving you all that respect for the passing of your loved one. The court would also look to the fact that statistics are showing us not just a few thousand, but tens of thousands of people are involved in motor vehicle accidents, many of them fatal every year across the country. And when you just look at your phone for even an instant, you increase your odds of a motor vehicle accident by a factor of 23. So that's X 23. So just looking at it for an instant, depending on what your speed is, if you're stopped, you can think you can go forward and then you might end up bumping somebody. If you're at speed, you can cover a football field or more. So it's just something that we have to remain mindful of. But thank you for hearing out that tiny dad lecture. Officer Donnelly, what would you like to share?
Nothing to add, Your Honor.
Thank you so much. What the court's going to do, Mr. Howard, is this ticket is somewhat financially daunting, so the court's going to afford some relief there and reduce the fine to $150. That is payable through the pay portal on the 44th District Court website, or you can walk a cash check or charge into this court at 400 East 11 Mile Road, Monday through Friday between 8:30 and 4:30. And that is going to be due within 14 days. That completes your hearing, and good luck to you, sir.
Well, friends, personally, I think he should add a $500 fine because we all know that if you're going to listen, not watch, but listen to anything on your commute, it should be TCF Live, and he did not comply. Alrighty, let's go back to, well, hi, Ellie. Here, come here. Say good morning to everybody. All right. Anyways, let's go back to Judge Oakley. It looks like they're coming back now from the little sidebar discussion that the pro se defendant was having with the prosecutor. Let's see how that worked out.
Some feedback from the users down there. Yeah, it's new. I'll say that. Yeah. Ms. Caitlin Foley, did you have conversation?
Yeah, we need to have a resolution for your child.
Okay, what is it?
Verbal license suspended, we will be dispensing the operating infraction vehicle as well as the unlawful use of license plate.
Okay. Mr. Blades, correct? You understand your rights and the options those rights present? You understand the possible penalty of the charge is up to 93 days in jail, up to $500 fines plus court costs? And that's the deal you want to make today? Did you drive a vehicle in Huron Township on November 29, 25? At the time, was your license showing as suspended, revoked, or denied from Secretary of State's records? Are you satisfied with the plea? I'll accept the plea to count 1, dismiss counts 2 and 3. Mr. Blades, let's talk about your financial situation. Are you working? Yes? Where do you work? I'm sorry, say it again. Bomar? Cromar. Where are they at and what do they do? Okay, how long you been with the company? Full-time job? Full-time job? And, all right, anything else you want me to consider before I sentence you? Yeah, lean up, yeah.
What do you find? Don't say no to my brother.
Tell me about it. In a word? Go ahead. Okay.
Scared. I have bills, I have friends, I have children, but I don't have a lot of playtime. I have to get back and forth to work. So that really has
Give me an idea, what kind of shift are you on? What kind of schedule? 2 p.m. to 10 p.m.? How many hours a week you're working? Okay, well, what's a minimum in a week? I mean, like 35, 40 every week, or it could be 0 to 40?
I get regular work daily, for how many hours I'm employed.
Okay. All right. So let me ask you this. Well, let me tell you this. We've got other files in this building. One of them goes back to 10 years old, 2016. Currently, you owe us over $3,000. I don't see any attempts to make any payments on these. Okay. All right. So, yeah, well, I'm not gonna pay a clerk to process a dollar payment. I mean, that's a net loss to the building. So I've got some options. Well, first of all, let's talk about the old money before we talk about today's file. On the $3,000, yeah, you guys don't have to stick around for this if you don't want to. For the $3,000, I can send you down and we can put you on the work program. Unfortunately, that means you got to be out here because we don't do the work program in Monroe. I can give you work days, which means you pick the days. The days you pick, you have to be here at 8 o'clock in the morning to go out with the crew. Or I can give you some community service hours, which means you work with a charity, nonprofit registered with the IRS. You can work off our list, or you can find someplace closer to Monroe County or, closer to home. But it's got to be an IRS registered nonprofit organization. You have to do X number of hours, document it on their official letterhead so we can confirm it with them and document that or present that to the court. So those are options how we can pay off that $3,000. All right. So I'm going to send you downstairs on the $3,000. I'm going to send you downstairs to talk options. All right. So on today's file, normally I sentence $500 on this. So I'll do, let's see, 4 days. What is today? Early. July 10th. All right, so on today's file, it's $500 or 4 days on the work program or 30 hours community service. One of those three has to be done between now and July 10th on today's file. You understand that? You want to do work program? Set that up downstairs. All right. And as far as the 3,000, they'll talk about your options down there, whether or not you want to do work days, charity hours, some combination, they'll work something out. Understand that work program days are assessed as an alternative to jail. That means if we give you a schedule, we expect you to be here, because if we give you that seat, we can't give it to somebody else. All right. So if we give you a schedule and you don't show up for one of those days, we'll give you, hold on, we'll give you a reschedule once. After that, you're probably doing the jail days. I can't hear you. The work program isn't, I just said that. Work program is done here. You have to, if you pick work program, you got to be here at 8 o'clock in the morning. I can't do it. I can't do it in Monroe County. My work program runs my 5 communities. I don't send a crew to Monroe County. The charity hours you can do in Monroe, but those aren't 4 days. Those are hours. Charity is hours. Work program is days, just like jail is days. So if you want to do the charity, go downstairs and talk about that.
The charity, that's not.
So on today's file, that means 30 hours between now and July 10th, documented by July 10th. Clear? Okay, go on downstairs.
Alrighty, friends. So he came to his senses and realized he was in over his head and took a deal. Probably should have done that earlier if he wasn't going to have a lawyer. Just my opinion. A couple of things in the chat. Eric, it's all about the Benjamins. Judge gets the cut. Not true. If it was all about the Benjamins, quite honestly, these guys wouldn't be waiving fines if they did community service or charity hours with organizations that aren't even tied to the court. So that doesn't hold, to be honest. I get what you're saying, but it doesn't hold. And then CMS, didn't he put a kid on a 70-hour work week on Friday? No, he did not. What he did on Friday or Thursday or whenever it was last week was he had a discussion with the young man about working hard now while he was young so he wouldn't have to later. And he said if he was still young, he would be putting in 70-hour work weeks right now because he's young and the body and the mind can handle it and take it. And I tend to agree with that. Just my opinion. Work while you're young. Put in the hours now so you don't have to later. That was the point he was trying to get across. Okie dokie. Let's go to Lake County, Judge O'Donnell.
Your Honor, we're hearing the matter of the State of Ohio versus Jennifer Marshall. This is case 26 CR 427. Ms. Marshall is present in court. She is accompanied by her attorney, Mr. Chad Mulkey. I believe we have reached a resolution in this case, and the defendant is prepared to withdraw her earlier entered plea of not guilty to count 1 of the indictment and enter a plea of guilty to that charge. In exchange, the state would then move to dismiss count 2. We would ask that the matter be referred for pre-sentence investigation report.
Mr. Mulkey.
That's all accurate, Your Honor. We are prepared to go forward. Thank you.
All right, Ms. Marshall, how old are you?
64.
And how far did you go through school?
I was a registered nurse. So I graduated high school, then I went to college.
Are you a U.S. citizen?
Yes, I am.
Are you able to read, write, and understand the English language?
Yes.
Prior to coming to court, have you taken any drugs or alcohol or any prescription medication within the last 48 hours?
Tylenol.
Have you ever been diagnosed or treated for any mental illness?
No, I haven't.
Did you get a copy of this indictment?
Yes, I did.
And you're going to plead guilty to count 1?
Yes, I am.
OVI, a felony of the 3rd degree. Is that accurate?
Yes.
Okay. Before I accept your guilty plea, I need to determine that you know and understand the constitutional rights you'll be waiving, the consequences of your guilty plea, and the maximum penalty I could give you, and I need to be satisfied that your guilty plea is being made freely, knowingly, and voluntarily. I'm going to ask you questions. If you don't understand a question, stop me. If you want to talk to Mr. Mulkey some more, let me know and I'll give you more time. Do you understand that?
Yes, I do.
You have a constitutional right to have a trial either to me or to a jury of 12 Lake County citizens. Do you understand that right?
Yes, I do.
Are you waiving that right?
Yes.
If you go to a jury trial, all 12 members must agree to a guilty verdict before you can be found guilty. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you go to trial, the prosecutor will call witnesses to testify against you. Do you understand the prosecutor must prove you guilty beyond a reasonable doubt at a trial? Do you understand that?
Yes.
After the witnesses are done testifying for the prosecutor, you have the constitutional right to have your lawyer cross-examine the witnesses. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you go to trial, you have the right to have witnesses come here and testify for you. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If those witnesses refuse to come to court, I'll issue an order that's called a subpoena to make them come and testify. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
You have the right to testify at trial if you want to. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
You have the constitutional right to not testify at trial if you do not want to. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you decide not to testify at trial, nobody is permitted to comment on that decision. Do you understand that?
Yes.
If you go to trial and you're found guilty, you have the right to appeal the guilty finding. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you file an appeal, you have the constitutional right to have a lawyer represent you in the appeal. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you could not afford to hire a lawyer, one would be provided at no cost to you. Do you understand that?
Yes.
If you file an appeal, you're entitled to have a transcript of all the hearings in this case. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you could not afford a copy of those transcripts, they'd be given to you at no cost. Do you understand that?
Yes.
If you plead guilty today, you will not have the right to appeal the guilty finding. Do you understand that?
Yes.
Do you have any questions about any of these rights?
No, I do not.
Do you still want to plead guilty to count one?
Yes.
Do you understand by pleading guilty, you're fully admitting your guilt to the charge?
Yes.
You understand by pleading guilty to this felony that you're voluntarily giving up your freedom for whatever period of time I could sentence you to prison, to jail, or to community control. You understand that?
Yes.
All right, the charge in count one of operating a vehicle under the influence of alcohol, a drug of abuse, or a combination is a felony of the third degree. It carries a maximum prison sentence of 60 months and a maximum fine of $10,500. Do you understand that?
Yes.
Now, there is also a mandatory prison term of at least 60 days. Do you understand that?
Yes.
And the fine in this case is mandatory. It's at least $1,350, but the maximum is $10,500, but it is mandatory. Do you understand that?
Yes.
Yes?
Yes.
There is also a mandatory participation in a drug and alcohol addiction program. Do you understand that?
Yes.
There's also a mandatory driver's license suspension of at least 3 years up to permanent revocation. Do you understand that?
Yes.
There's also a mandatory forfeiture of the vehicle used in the offense if it is registered to you. Do you understand that?
Yes.
Any question about any of the penalties?
No.
All right, do you understand that if a prison term is imposed, well, in addition to the prison term, if I could place you on probation for up to 5 years, community control for up to 5 years after your prison term. Do you understand that?
Yes.
After you're released from prison, depending if I don't put you on community control, then you could be placed on post-release control under the parole authority for up to 2 years. Do you understand that?
Yes.
If that happens, they would put conditions on you. If you violate the conditions, they could return you to prison for up to 9 months for each violation, up to 1/2 of my sentence. Do you understand that?
Yes, I do.
If that violation is a new felony, then you could get an additional consecutive prison sentence for the violation. Do you understand that?
Yes.
And if that were to occur, the maximum prison sentence for that violation would be the greater of 12 months or the time left under post-release control. Do you understand that?
Yes.
Now, if I give you the some prison sentence in this case and then put you on community control, if you violate the conditions of your community control, then you're subject to that 60-month prison sentence. Do you understand that?
Yes.
Do you also understand that if a prison term is imposed after you serve the mandatory portion, you are eligible for judicial release? You understand that?
Yes.
Now, has anybody promised you that I would be lenient on you just because you're pleading guilty today?
No.
Has anybody promised you what I will sentence you to in this case?
No.
Do you understand I do not have to follow the sentencing recommendation of either the prosecutor or your lawyer?
Correct.
Have you had enough time to talk with Mr. Mulkey before pleading guilty today?
Yes.
Has he discussed everything about your case and answered all of your questions?
Yes.
Are you satisfied with the advice he has given you?
Yes.
Have you been threatened or coerced in any way to plead guilty today?
No, I haven't.
Are you freely, knowingly, and voluntarily entering your guilty plea?
Yes, I am.
Do you have any questions?
No, I do not.
All right, Ms. Mulligan, if the case went to trial, what would the evidence show?
Your Honor, the state would be prepared to show that on March 7th, 2026, at around 4 in the morning in Painesville Township, Lake County, Ohio, the defendant was driving on State Route 2 with no headlights. She was stopped by a trooper of the Highway Patrol who observed signs of alcohol impairment, including bloodshot eyes, odor of alcohol. And she did perform poorly on a field sobriety test. She made admissions to having consumed alcohol, and she'd previously been convicted of a felony OVI in Lorain County in 2018.
All right, Mr. Mulkey, anything to add to those facts?
No, Your Honor.
All right, Ms. Marshall, did you hear what Ms. Mulligan said that the facts would show if the case went to a trial?
Yes, I do.
Are those facts true?
I did. Yes.
All right, then what is your plea to operating a vehicle under the influence of alcohol, a drug of abuse, or a combination, a felony of the 3rd degree?
Guilty.
Mr. Mulkey?
It is 6/2/26. You don't need that copy, do you?
Your Honor, Ms. Marshall has signed the written plea of guilty. Her signature will get inspections.
Ms. Marshall, is this your signature on the written plea of guilty?
Yes.
Did you sign it voluntarily?
Yes.
Do you want me to accept your written plea of guilty?
Pardon me?
Do you want me to accept your written plea of guilty?
Yes.
And I'll accept the written plea of guilty. Defendant was present when Mr. Mulkey advised of all of her rights, made a knowing, intelligent, voluntary waiver. She understands the nature of the charge, the consequences of her guilty plea, and the maximum penalty. Find it to be knowing, intelligent, and voluntary. I will accept her plea of guilty and find her guilty of count 1, OVI, a felony of the 3rd degree. I'll refer this for a pre-sentence report. And a drug and alcohol evaluation. Sentencing will be July 22 at 1 p.m. and the bond is continued. Anything further, Ms. Mulligan?
No, Your Honor, thank you.
Mr. Mulkey?
Not at all, Your Honor. Thank
All
you.
right, we're adjourned.
All rise.
Okie dokie, friends. Barbara, $5 super chat times 2. First one, prayers for me to survive this heat. Surviving heat prayers are part of our regular prayers here at the bunker, being desert dwellers, so totally get it. And then Dan, thanks for being the best host on YouTube. We all appreciate you and all you do for us. Thank you for that compliment, Barbara, and I appreciate that. And then Eric, 10 Canadian dollars. Put this towards my fines I may accrue in the future. I will do that. Thank you, Eric. It'll probably get you through the next 90 minutes or so, but I'll let you know when it's run out. Alrighty, let's Let's go down to Florida. Wade Mercer.
Can see and hear you, sir.
Muy buenos días, señor Flores Serrano. Mi nombre es Jordani Ricardo, intérprete para que se pueda comunicar con el juez. ¿Usted me ve y me escucha?
Yes. Buenos días.
He can hear me and see me, Your Honor. Good morning.
Thank you. Mr. Flores, you're here because we're trying to see if we can resolve your pending no valid driver's license charge.
Señor Flores está aquí porque estamos tratando de ver si podemos resolver su cargo pendiente de no tener licencia de conducir válida.
I'm appointing the public defender's office to represent you, and I'm going to ask that you listen to Mr. McDaniel.
Le voy a asignar al abogado de oficio para que lo represente y le pido que escuche al señor McDaniel.
Your Honor, I spoke to Abraham. He's going to enter a plea of no contest to charges listed.
Su señoría, hablé con Abraham. Él se va a declarar no me opongo ante los cargos, tal y cual se le acusan.
Understanding 9 days in county jail, credit for 9 days, $400 fine.
Se le condenará a 9 días en la cárcel del condado con crédito por 9 días y una multa de $400.
It's a civil judgment that goes against his credit rating. He also understands that ICE has placed a hold on him.
Sería una multa civil que se usaría en contra de su crédito. Él también entiende que inmigración le dio una orden de retención.
Waived right to jury trial and call witnesses and understands that any plea can be used against him in immigration court.
Ha renunciado a su derecho a un juicio con un jurado y a llamar a testigos y entiende que cualquier acuerdo se puede usar en su contra en el Tribunal de Inmigración.
Mr. Mitchell, is that agreeable with the state?
It is, Your Honor.
Señor Mitchell, ¿está de acuerdo el Estado o lo está su señoría?
Mr. Flores Serrano, did you hear that agreement?
Señor Flores Serrano, ¿escuchó usted ese acuerdo?
Yes.
Yes.
Do you have any questions about that agreement?
¿Tiene alguna pregunta acerca del acuerdo?
No.
No.
And is that the plea you would like to enter?
¿Ese es el acuerdo que usted desea aceptar?
Sí.
Yes.
I'm going to accept your plea of no contest to the charge of driving with no valid driver's license.
Voy a aceptar su declaración de no me opongo ante el cargo de manejar sin licencia de conducir válida.
Withhold adjudication of guilt and sentence you to 9 days in the county jail.
Le suspendo el fallo de culpabilidad y lo condeno a 9 días en la cárcel del condado Jackson.
But you have credit for 9 days that you've already served.
Pero tiene crédito por 9 días que ya ha cumplido.
I'm also going to impose the standard court costs and fines of $400. That will be reduced to a civil judgment.
También le impongo las multas y costas estándar de $400 que se reducen a un fallo civil.
The United States Immigration Service will be notified after first appearance to pick you up, sir.
Después de la comparecencia inicial, se le notificará a los servicios de inmigración de Estados Unidos que lo recojan.
And they have 48 hours to pick you up.
Y ellos tienen 48 horas para recogerlo.
Do you have any questions?
¿Tiene alguna pregunta?
No, sir.
No.
Have a good day, sir.
Que tenga buen día, señor.
Victor Castillo. Victor Castillo is next.
And Your Honor, does Mr. Flores Serrano have a case number yet?
26274 CT. Maybe if you send me your email, I sent all those case numbers to your, I think it's your private email though. I sent them to, I don't have any other email for you though.
Okay, I'll give you my work email.
You can text it to me or something later. Or email it to me.
I appreciate it.
Mr. Castillo, you're here this morning for the charge of driving under the influence, driving without a driver's license.
Señor Castillo, está aquí esta mañana por el cargo de manejar bajo los efectos del alcohol y manejar sin licencia.
As well as resisting an officer without violence and a hold from the Immigration Service.
Así como resistir a un agente sin violencia y una orden de retención de parte del Servicio de Inmigración.
I'm appointing the public defender's office to represent you and asking that you listen to your attorney, Mr. McDaniel.
Le voy a asignar la oficina del abogado de oficio para que lo represente y le pido que escuche a su abogado, el señor McDaniel.
All right, I spoke to Victor in case number 26246 MM. He's going to plead no contest to the charges as listed.
Su señoría, hablé con Víctor en la causa 26246 Él se va a declarar no me opongo ante los cargos tal y cual se le acusa.
60 sentenced to 60 days in the county jail, 24 days jail credit, $1,078 in fines, which will be a civil judgment.
Se le condenará a 60 días en la cárcel del condado con crédito por 24 días, $1,078 que serán un fallo civil.
Waiver his right to a jury trial and call witnesses and understands that any plea can be used against him in immigration court.
Está renunciando a un juicio con un jurado y a llamar a testigos y entiende que cualquier acuerdo en un caso penal se puede usar en su contra en el Tribunal de Inmigración.
He understands when he finishes these last remaining days that he'll go to ICE as they're going to pick him up.
Él entiende que cuando vaya terminando los últimos días va a pasar con inmigración ya que ellos lo van a recoger.
Thank you. Mr. Mitchell, is that agreeable with the state?
It is, Your Honor.
Señor Mitchell, ¿está de acuerdo el Estado? Lo está su señoría.
And Mr. Castillo, did you hear that agreement, sir?
Señor Castillo, ¿escuchó usted ese acuerdo?
Sí.
Yes.
Do you have any questions about that agreement?
¿Tiene alguna pregunta acerca del acuerdo?
Una pregunta. Solo una pregunta.
Just one
Podría
question.
ser, ¿Qué
¿Cuál
podría
es su
hacer qué podría hacer para poder seguir aquí en este país?
What can I do? What can I do in order to remain in the country?
That's an issue you've got to resolve with the United States Immigration Service. I can't, I have nothing to do with that, okay?
Eso es algo que tiene que resolver con inmigración. Yo no tengo nada que ver con eso.
Do you have any questions about your local charge, your local plea agreement, sir?
¿Tiene alguna pregunta acerca de su cargo local, acerca del acuerdo local?
Ok, todo bien.
No, it's all good.
I'm going to accept the plea of no contest of these three charges: driving under the influence, no valid driver's license, and resisting an officer without violence.
Voy a aceptar su declaración de no me opongo ante los tres cargos: manejar bajo los efectos del alcohol, no tener licencia de conducir válida y resistir a un agente sin violencia.
I judge you guilty of those offenses and sentence you to 60 days in Jackson County Jail.
Lo condeno culpable de los delitos y lo condeno a 60 días en la cárcel del condado Jackson.
The 60 days will be on all three charges, but it's concurrent, so it's one total sentence of 60 days.
Los 60 días serán simultáneos, así que será 60 días por cada uno de los cargos, pero 60 días en total.
You have credit of 24 days towards each sentence.
Tiene un crédito de 24 días hacia cada una de las sentencias.
And a fine of $1,078 only on the DUI case.
Y una multa de $1,078 solamente en el caso de manejar bajo los efectos del alcohol.
Waiving the court costs and fines in the other two cases.
No lo estoy eximiendo de las multas y costas en los otros dos casos.
If you get the court costs and fines worked off at the jail, then great. If not, it'll be a civil judgment against you.
Si trabaja por las multas y costas en la cárcel, excelente. Si no, se convertiría en un fallo civil en su contra.
And the Immigration Service will have 48 hours to pick you up, but that time will not begin until you complete your sentence here.
Inmigración tendrá 48 horas para recogerlo, pero ese tiempo no comenzará hasta que haya cumplido con su condena aquí.
And Mr. Castillo, once you get to immigration court, that's the appropriate place and for people to ask the question that you asked me.
Y señor Castillo, una vez que llegue al Tribunal de Inmigración, ese es el lugar donde debe hacer la pregunta que me hizo a mí.
Okay.
Do you have any questions, sir?
¿Tiene alguna pregunta, señor?
Todo bien.
It's all good.
Wish you the best, sir.
Le deseo lo mejor, señor.
Mr. McDaniel, I believe we have Ledwin Avila, but that individual posted bond and is now in immigration custody. Is that right?
Correct.
So do we have anybody else on the docket this morning we need Mr. Ricardo for?
Mr. Ricardo, I'll let you know, I sent you that email in case you do see it. It says 9:30, but I'm sorry, it's 10 o'clock this morning. I don't expect anybody to be there this morning because the one is that, I think one has been deported. The other one has taken into ICE custody yesterday. There's no way he's out, but We do have those two at 10 o'clock.
I don't know that that's his docket, though. The interpreter form I've got shows Mr. Cordova for 10 o'clock. Mr. Ricardo, do you even have that docket?
No, Your Honor, it's Mr. Cordova for that docket.
Okay. So, Mr. McDade, remind me at the end, and we'll go through those. I've got the docket here. I think there's one case I had a question about whether or not we need to be here for. Thank you, Mr. Ricardo.
Thank you, Your Honor.
We do have Mr. Friedman's case next, and that is State of Florida versus Gabriel Nunziata.
Yes, Your Honor.
Mr. Nunziata, good morning. Mr. Nunziata, you're here because you're accused of one count of violating the terms of your conditional release PTI, pretrial intervention program. Mr. Nunziata, my understanding is that you turned yourself in to get this matter resolved. Mr. Friedman is here on your behalf, and Mr. Ham with the probation office told me this morning, Mr. Friedman, there was some very extenuating circumstances regarding Mr. Nunziata's case, and that you would be able to fill us in with more detail. So, Mr. Nunziata, listen to your attorney, Mr. Friedman. He's going to tell us the rest of the story, what he thinks we need to know, and then we'll see what Mr. Mitchell's position is once he hears all of that. Mr. Friedman.
Yes, Your Honor. My clients give me permission to speak about this, even though this is being live streamed. Mr. Nunziata was in school at the time this occurred. His older brother was suffering from severe depression and attempted suicide. Mr. Nunziata eventually withdrew from multiple classes, trying to help his brother, who eventually succumbed and who killed himself in February of this year. Mr. Nunziata and his family tried to recover from that, and Mr. Nunziata is currently in school right now, taking 6 classes, because he's able to transfer to FSU to finish his degree at the end of this semester. And he fully acknowledges all he had to do was send the emails, and he just messed that up, but he was in a pretty dark place at the time due to his brother's suicide attempt and eventual suicide.
Thank you, Mr. Friedman. Mr. Goodson, other than not reporting you reported several months and stopped reporting is what the violation affidavit says. Other than those months he misreported and what supervision may have been due for those months, are there any other violations?
No, sir.
I can't hear. I don't know who that is talking out there at the jail.
I think that's Mr. Pullman.
Well, we need to get them out of that room if they're going to continue to cause a problem. We'll see them at the end. So, Mr. Goodson, you were saying?
No, sir. He had a $250 cash bond, so that was applied to the 270 court costs. He did pay the additional 20, and he paid up front $180 for 6 months of COS. So the other 180 on there for the last 6 months. Yes, sir.
Thank you. Mr. Mitchell, I did go look at the original complaint to see the basis for the battery, and it was allegedly spitting on someone. It is what it is. What's the, and lastly, your client did come and turn himself in when he found out about this warrant. Is that correct, Mr. Friedman?
Yes, Your Honor. When he was applying, he contacted the clerk and realized that this case was not dismissed. He thought it was. And he said, I got to go turn myself in. So that's what he did.
Mr. Mitchell, given that, what is the state's position? Or do you have questions or any issues you want to raise?
No, Mr. Freeman and I talked about this yesterday. He relayed that information on, and that information was to be relayed to the court. I sort of informed Mr. Friedman that given that it was a show cause order in that situation, you may be looking for a jail sentence, but I mean, given the circumstances of the reason why he didn't fail to report, I am okay with just kind of time serving him, given something shorter in that situation.
Here's the situation you've got. You've got a PTI, so it's entirely in your hands. It's not a plea. It's not a violation of probation. It's a violation of pretrial intervention. So you have to decide if you want to just terminate him and be satisfied with the effort he's put forth and the extenuating circumstances or not. I'm not going to take any separate action on the alleged contempt based upon what I've heard today. So you've simply got to decide if you're satisfied that he's substantially completed the pretrial intervention to the point where you're going to dismiss it or not.
Given his completion of it so far and given the extenuating circumstances, I will move to dismiss the case today.
Okay, thank you. So, Mr. Nunziata, first of all, let me say I'm sorry for your and your family's loss, but you've handled this the correct way. You turned yourself in. You did what you were supposed to do. You've got a good attorney advising you. Mr. Mitchell satisfied that you paid everything. You reported in for several months. You stopped reporting due to some tragic circumstances, and that's understandable. So this case against you is being dismissed. In other words, you've essentially completed enough of the pretrial intervention for the state to be satisfied. They're dismissing the case against you. You'll be released today, and I do wish you the best with your continuing education. Mr. Nunziata, do you have any questions?
No, sir.
Mr. Friedman, did I miss anything, sir?
No, sir. Thank you, Your Honor.
Thank you, Mr. Friedman. Mr. Mitchell, anything else?
No, Your Honor.
All right. Thank you. Y'all have a great day. We do
Thank
have
you
a
both.
couple of
Maybe-
people that have
maybe
friends or
excuse-
family here.
He was just asking if he can be excused.
Oh, yes, please. Thank you. Thank you, Mr. Friedman. We have, is it Mr. Jones? We have friends or family here on Preston Jones. Mr. McDaniels, let me see him next. Mr. Jones, good morning. Mr. Jones, you're here because you've been accused of one count of simple battery. Your
Yes, sir.
parents and you've got a couple of other family members that are in the courtroom. Mr. Jones, there is probable cause for the charges. I'm appointing the public defender's officer to represent you. Mr. Jones, the criminal history I've been provided shows that you are 18 years of age or
Yes, sir.
19 with no prior history. I guess 18 with no prior history. Is that accurate?
Yes, sir.
Okay. Listen to Mr. McDaniel and we'll see where we go from here, please.
Your Honor, we just asked for some kind of cash bond. I mean, this is a, it is what it is. It's horseplay, and I don't know what it is. It's kids being kids, I think, but it's, over a game or something. No, this is with his brother, and we just asked for maybe some kind of cash bond.
The alleged victim is your brother. The complication is where he's going to live. So I'm talking to the family now. So
Brother doesn't live there, I don't think, Your Honor, so.
okay. So the brother lives in what town? Same town or?
Yes, sir.
But
Same
not
town.
the same property at all? Okay.
No, sir.
Sometimes we'll have issues if it's two homes right next to each other. That's not the case, correct?
No, sir.
And so, Mr. Jones, I'm gonna let you pick, well, let me ask Mr. Mitchell, do you have any objection to the cash bond request?
No objection, Your Honor.
I'm gonna let you pick between the conditional release and the cash bond. If you want the conditional release, that's fine. If you want the cash bond, that's okay too. The cash bond will be $250 cash. The benefits to a cash bond is if the case is dismissed, it's returned to whoever posted it. And if it's not dismissed and there are court costs and fines imposed, then it goes towards court costs and fines. That's how a cash bond works. So it's a $250 cash bond. If he prefers that, I am offering the conditional release because of his lack of criminal history. He does have a condition of no contact with the alleged victim, at least temporarily. If they both want contact, we'll cross that bridge down the road. Mr. Jones, do you have any questions about that choice?
No, sir.
Do you prefer the cash bond or the conditional release?
I say let Mom choose. Mom's in the courtroom.
So, ma'am, the conditional release has more rules to follow. It's got to report in once a week. The cash bond has fewer rules. Okay. Okay. And it will be returned if the case is dismissed. I don't know if it will be dismissed, but if it is, it's returned to whoever posted it. Okay. Your mom says she'll post the cash bond for you, Mr. Jones. You're going to get out of jail as soon as that bond is posted. It's cash, it's $250 cash to the jail, and then he'll be released. And the jail will give him a notice for his court date. His court date will be June 29th at 9 a.m. They'll give you that notice. If your case is still pending, that's the day you've got to be in court. Of course, if Mr. Mitchell's office has dismissed the case before then, and you know that, you've got documentation of that, you don't have to be in court. Mr. Jones, do you have any questions?
No, sir.
Wish you the best, sir.
Yes, sir.
We also have Krista Polis has friends or family here. Ms. Polis, your mother is in the courtroom. Ms. Polis, you're here to see if we can resolve your pending breach of the peace case in 25519 MM. Please listen to Mr. McDaniel. I'm appointing his office to represent you, ma'am.
Okay, thank you, sir.
Your Honor, I spoke to Ms. Polis. She's going to plead of no contest to the charges listed. She'll be sentenced to 16 days in county jail, credit for 16 days, $370 fine. And I don't think she's got any history, so I just asked the court to withhold adjudication. And this case has been out here for a while because she was in the institution for quite some time.
Let me take a look at that history. Yeah, she's got a DUI, Delray Beach, another DUI in Palm Beach County.
She's been
Yeah,
adjudicated.
she's got,
Matter.
yeah,
That's fine.
she's got 2013 battery. She's got some history. So, Mr. Mitchell, is that all agreeable with the state?
It is, Your Honor.
Ms. Polis, if you enter this plea, I'm going to adjudicate you guilty based upon your history in the jail sentence. Ms. Polis, do you have any questions about that agreement, ma'am?
No, sir.
Is this the plea you would like to enter?
Yes, sir.
Ms. Polis, I'm going to accept your plea of no contest to the charge of breach of the peace in case 25519 MM. A judge who guilty of that offense sentenced you to 16 days in jail, but you have credit for 16 days you've already served. $370 court costs and fines are imposed. So let me talk to your mother. What they'll do next, ma'am, when she's through with this case, it's over. The jail has to do a warrants check on her. Anytime someone gets out of jail, they have to check warrants for outstanding counties and states. As long as there's no warrant, she'll be released this morning. If there is a warrant, we have to find out if there's a bond on that warrant and where it's from and so forth. So as long as she has the warrant, she'll be released in the next half hour. Are you going to be able to pick her up? Okay. So your mother says she's made arrangements to have you picked up, Ms. Polis, but you still get to use the phone after first appearance if you wish. Ms. Polis, do you have any questions?
No, sir.
The best, ma'am. Hang on, our clerk has a question. Yes, ma'am. Yeah, I didn't say that. Yeah, it'll be a civil judgment on the fine since you don't have the ability to work it off since your sentence is over with. So it'll be a civil judgment, and what that means is that the clerk's office waits 60 days. If you pay it, it's over with. If you don't pay it, they have to report it to the state of Florida, who will suspend your driver's license for it. So essentially, you have 60 days to pay it or reaching a payment arrangement plan with the clerk's office. And if you do neither of those, your driver's license goes to get suspended. Okay.
Okay, thank you.
All right. Wish you the best, ma'am. Thank you for coming, ma'am.
Thank you.
Thank y'all for coming too on that case. Okay, so we do have some more friends or family that just came in after we got started, Mr. McDaniel, and they are on Mr. Holland. State versus Marcus Holland. I've got mom and brother, is that right? Mr. Holland, your mom and your brother both are in the courtroom. You're here because you've been accused of violating the terms of your state probation. I have a copy of the no bond warrant in front of me, signed by the circuit judge. In this case, it's Judge Garcia. Mr. Holland, I'm going to get you arraigned this morning. What that means is I want to get you a lawyer appointed if you're asking for one. Mr. Holland, would you like to have an attorney appointed to represent you?
Yes, sir.
I'm going to appoint the public defender's office to represent you, Mr. Holland. Listen to Mr. McDaniel, and we'll see if you have any questions in just a minute.
Your Honor, we're going to plead not guilty. Yes, to set this in the July 9th pretrial docket, and I advise the attorney from the public defender's office to visit him prior to that hearing.
Thank you. Mr. Mitchell, anything from the state?
No, Your Honor.
So, Mr. Holland, your attorney will see you at the jail before that court date. Mr. Holland, do you have any questions?
No, sir.
And let me see if your family has any questions. Any questions? No? All right. Wish you the best, sir.
Thank you.
Thank you. So, Mr. McDaniel, that's it for friends or family in the courtroom. We can go down our list. The next case is Lamia Douglas. Douglas, good morning. Ms. Douglas, you have two issues. You've got to charge case 26-69 CT, which is the offense of leaving the scene. I think there's a typo on the jail list. It says breach of the peace, but it's actually leaving the scene of an accident. And then in case 24-210 CF, you're charged with violation of state probation. Let me go ahead and deal with the violation of state probation first. If you would like to have an attorney appointed to represent you in that violation of probation, I'm going to go ahead and get you one appointed. And Mr. McDaniel will give you a court date and see if you have any questions in just a moment. Would you like to have an attorney appointed to represent you in that VOP, Ms. Douglas?
Yes, sir.
All right. So in that case, you've got no bond. I'm appointing the public defender's office to represent you. Listen to Mr. McDaniel in that case, and then we'll deal with the misdemeanor charge.
Your Honor, we're going to go ahead and enter plea of not guilty. Yes, set this on July 9th, and I advise her attorney to come visit her prior to that hearing.
Thank you. Ms. Douglas, do you have any questions about the VOP? Okay, that leaves the other charge, which is leaving the scene of an accident. And in that case, I'm appointing the public defender's office to represent you and ask that you listen to Mr. McDaniel.
Your Honor, we're going to enter plea of no contest to that charge. 30 days in the county jail, 1 day credit, $408 fine. That will resolve this case today. She did waive her right to jury trial and call witnesses.
Thank you. Mr. Mitchell's had agreeable to say. And in that case, Ms. Douglas, do you have any questions about that agreement?
I don't.
And is that the plea you would like to enter to resolve that case, ma'am?
I don't think I have a choice, so yes.
If you have a choice, you can say that you don't want to enter that plea and we'll just start moving towards a trial. If you want to resolve it, you can. It's entirely up
I
to
don't
you.
want to go to trial. The 30 days is fine with me.
I'm going to accept your plea of no contest then to the charge of leaving the scene of an accident without giving the information required by Florida law. A judge or guilty sentenced you to 30 days in jail. You have credit for 1 day you've already served. $408 court costs and fines. Okay, let me finish my thought here. The $408 court costs and fines will be a civil judgment if you don't get it worked off at the jail, and you very well may get it worked off at the jail. Yes, ma'am, your question.
Okay. You said without giving info. When did I ever talk to a police officer? That's what I'm trying to
That's the
figure out.
problem. According to the complaint, you left before law enforcement got there. So you left, so you didn't give info to anybody.
I
Before
don't
the law
remember none of
requires
this
you to,
anyways.
ma'am.
I don't remember none of this anyways, but 30 days
Okay.
is fine. I ain't got no more to say about it.
All right. Have a good day. All right. So that takes care of Ms. Douglas's case, and I believe brings us to James McLean.
It's crazy.
Mr. McLean, good morning. Mr. McLean, you're here for first appearance. You're accused. You've already got bond set in other cases. You've got 2 new charges that have came in, Mr. McLean. They are grand theft between $750 and $5,000 and burglary of an occupied structure. Mr. McLean, there is probable cause for these charges. I think you're entitled to a bond for these cases. I'm prepared to set you a bond, but I'm going to listen to the attorneys first. So let's see if the attorneys have any additional information. Mr. McDaniel?
Nothing, Your Honor.
Mr. Mitchell?
Nothing, Your Honor.
So, Mr. McLean, these 2 third-degree felonies, your bond's going to be $5,000 each. So your bond today is $10,000 with a condition, no contact with the alleged victim or their property, plus whatever bond you previously had set. Mr. McLean, do you have any questions?
Yes, sir. Who is the alleged, like, who is saying I done this? Because I ain't broke into nothing. Man, I've been home for almost a year, and I mean, I just caught a possession charge the other day. To be honest, man, the dope that he found. No, man, because the dope wasn't mine. Man,
Mr.
no,
McLean,
man.
this was supposedly, according to the complaint, this is captured on video, and I'm going to tell you the victim's name and the alleged victim's name in just a minute.
Shane Griggs and Linda Offhouse.
Shane Griggs and Linda Offhouse, and according to the complaint, this is on video. Do you have any other questions?
Yeah, man, they took $2,600 of my money, dude.
Okay.
No, that's not a question. That is a statement. That is a proven fact, man. Okay. Proven fact. I have witnesses.
You have a question?
No, I ain't got no question. Yeah, can I? Yeah, Your Honor, can we go ahead and get all this stuff arranged? Because I ain't, man, this is like, Your Honor, look,
legally, I cannot arraign you until the state makes a charging decision. They may charge you with misdemeanors. I have no idea. So they have a certain amount of time to charge you, and then once you're charged, you're arraigned. So I can't arraign you today.
I think he was already given a notice for July, or no. What is it? June, July?
What would be his court date, Corporal? Or
July 7th, I think is what it is.
July 2nd. So we're going to do everything on that one day to go ahead and get these cases moving. I'll ask the jail to give you a notice for that same. Don't shake her head. No.
Is it the 7th?
Your Honor.
Just a second. Let's get your court. Just a second. Let's get your court date figured out first.
Damn. I returned this stuff to me.
Okay, there is no July 2nd court date. Mr. McDaniel, we need to get this straightened out. July 7th? Corporal, someone tell me, is that?
Yeah, July 7th. July 7th. He's telling me now.
Your court date will be July 7th. Now, do you have any more questions?
No, Your Honor, all the stuff that they're accusing me for stealing, I returned to them. As soon as that woman, she called me, and the only reason, Your Honor, only reason I took this stuff is because that man took $2,600 of my money. I purchased the vehicle. No, I mean, I purchased the vehicle from this man, dude. And so you're going to hit the end button when I'm trying to talk to the judge. Like the lady.
Mr. McLean, you need to talk to your attorney in private about your defenses or your potential defenses, sir.
I'm going to be making a request for that blue man, Don. Okay.
The names of the alleged victims was familiar.
Yeah.
In the court system. The next case we have is, I don't know if I said no contact with alleged victim on Mr. McLean's case, but obviously I have to. No contact with alleged victim. Savannah Castaneda. Ms. Castaneda is here in case 26-126 MM. Ms. Castaneda, listen to Mr. McDaniel, please.
Okay.
Your Honor, I spoke to Ms. Castaneda. She's going to enter a plea of no contest to the charge of trespass and understanding she should be sentenced to 73 days in jail, credit for 73 days, $370 fine, and withhold adjudication. She don't have any criminal history. So I don't think the state's going to object to that.
or not, Your Honor, and that is agreeable with the state.
Ms. Castaneda, did you hear that agreement, ma'am?
Yes, sir.
And Ms. Castaneda, do you have any questions about that plea agreement?
No, sir.
Ma'am, is that the plea that you would like to enter?
Yes, sir.
All right, Ms. Castaneda. Mr. Goodson, anything else in this case?
When she originally got placed on PTI and she was sent to the treatment facility, she could possibly work off her fine at the treatment facility. I don't have any documentation. I don't know if she did or she didn't, Judge. I'm just gonna put that on the record.
She left the treatment facility without completing the program, correct? Allegedly. Okay, so Ms. Castaneda, I'm gonna do a civil judgment on the fine, ma'am. Is it still the plea you want to enter, ma'am?
Yes, sir.
All right, I'm gonna accept your plea of no contest in case 26-126 MM to the charge of trespass, occupied structure or conveyance, withhold adjudication of guilt, sentence you to 73 days, ma'am. You've got credit for 73 days you've already served. 370 court costs and fines are imposed. That'll be a civil judgment. Ms. Castaneda, the jail will do a warrants check on you. I don't know of any warrants. Don't expect any. As long as you don't have any warrants, you'll be released this morning. Do you have any
Yes, sir.
questions, ma'am?
No, sir.
Judge, you have
ma'am,
any issues with her working off those fines within 60 days for the civil judgment? She's going over to Louisiana, I think, to the
Safe house.
whatever that is in Chrome in Louisiana. So I don't know if she can get us something, but maybe if she can, maybe they can.
I don't think we have a mechanism in place to work off court costs and fines after a jail sentence. There's no probation. I don't know of any way to do that. We've never done that before. So, Mr. McDaniel, if that's something we want to try to figure out a mechanism to structure that, we can, but I'm not going to do it on the fly. I don't know how we would verify it or anything, or when she would turn it in. I don't want to go down that road without thinking about it. So possibly in future cases, but I've never been asked that before, Mr. McDaniel. So no, her case is over with. I can't require her to do community service after it's over with.
Thank you.
Wish you the best, ma'am.
Thank you.
We've already seen Ms. Polis. Next is Detson Phillips. Mr. Phillips, good morning. Mr. Phillips, you're here in case 26271 CT for the charge of driving while license suspended or revoked knowingly, as well as case 26108 MM for the charge of violation of county probation. I'm appointing the public defender's office to represent you in both these cases. Please listen to Mr. McDaniel, your attorney.
Your Honor, I spoke to Mr. Phillips in case number 26271 CT and in case violation of county probation, case number 26108 MM. He's going to enter plea of no contest and admit that he violated his probation. Understanding he'll be sentenced to 60 days in county jail, 13 days jail credit, all run concurrent, $400 fine plus whatever remaining fine is owed on the violation of county probation. He has waived his right to jury trial and call witnesses.
Thank you, Mr. Gibson.
$250 on the violation is his balance. Yes, sir.
Thank you. Mr. Mitchell, is that agreeable with the state?
It is, Your Honor.
And Mr. Phillips, did you hear that agreement?
Yeah.
Mr. Phillips, is that the plea you would like to enter?
Yeah.
All right. Mr. Phillips, I'm going to accept your admission that you violated the terms of your probation in that case number 26-108, as well as the plea of no contest to the new charge. I'm going to find that both freely and voluntarily entered. I'm going to sentence you to 60 days in both cases concurrent. Judge guilty of both offenses, give you credit for 13 days you served in both cases, $400 court costs and fines, and the new charge, $250 court costs and fines remaining in the old case. If you get those worked off, great. If not, there'll be a civil judgment against you, Mr. Phillips. There's no probation involved in this sentence. You finish this jail sentence, this is all over with. Do you have any questions, sir?
No, I'm good.
Okay, he did have a hold at one time. There's nothing on the jail sheet. Does he still have a hold somewhere else, Corporal, so he knows?
Yeah.
Mr. Phillips, on one of the arrest reports, I saw a hold from another state. I don't know if that's still active or not.
It's DeKalb County, Georgia.
Just be aware you may have a hold. If you do, we'll see you when you get near the completion of your sentence. Talk about a waiver of extradition if they still want you. They may not, but if they do, we got to deal with it, okay? Have a good day, sir. We have Sandacia Dennis next. Dennis, good morning. Dennis, you're here because you've been accused of violating the terms of your probation in case 24-464 MM on probation for the charge of petty theft. Ms. Dennis, I'm appointing the public defender's officer to represent you, and I'm going to ask that you listen to your attorney, Mr. McDaniel.
Your Honor, I spoke to Ms. Dennis. She's going to admit that she violated probation, understanding 30 days in jail, 16 days credit, and whatever remaining fine. That'll resolve this case today.
Yes. Mr. Mitchell's at agreeable with the state.
It is, Your Honor.
Mr. Goodson.
Yes, she had a $270 fine arrearage and a 181.34 restitution.
And she paid neither?
No, sir, she hadn't paid anything.
Thank you. Ms. Dennis, did you hear that agreement, ma'am?
I did, yes, sir.
Ms. Dennis, do you have any questions about that agreement?
I was kind of hoping because I didn't get a new charge. Could pay the fine to get out, but I guess that wasn't negotiable. So I don't mind, I guess, doing the time.
The allegations are that you quit reporting, ma'am, and normally if it's just financial, if that's all it was is financial, in other words, they did everything they were supposed to do, but they still owed some money at the end. Most of the time, the state will agree, and I will sentence them to a purge, which means they get released when they pay. But your case, it was more than financial. That's why you've been made the offer you are, ma'am.
Okay, that's fine. Well, I lost my job, I went through depression, but like I said, it's fine. I just find the timing is fine. Cool.
Okay, you're talking kind of fast. I heard you say something about a job. Tell me about that.
I work for Citizens, and they did the company layoffs, so I got let from my job. So I'm laying off from my job, caused me to go into depression. That's why I stopped reporting. I kind of lost everything, so I didn't, but it's fine.
I understand. Thank you for explaining that. Is this still what you want to do, ma'am? Is this what you want to do?
Yes.
All right, Ms. Dennis, I'm going to accept your admission that you violated the terms of your probation. I'm going to revoke that probation in case number 26-564 MM. Ma'am, I'm going to adjudicate you guilty of that offense and sentence you to the time of sitting 30 days in the county jail. You have remaining court costs and fines in the amount of, Mr. Guston, I didn't write those down. $270 court costs and fines. You also have restitution in the amount of
$181.34.
$181.34. You'll get a chance to work off the court costs and fines. If you do, they'll be over with. If not, there'll be a civil judgment for that amount. You can't work off restitution, so there'll be a civil judgment for that restitution amount, but there's no probation to follow. You finish this sentence, ma'am. This is all behind you. You put this all behind you. Any questions, ma'am?
So when will be my sentence release date?
Talk to the jail.
Okay. Thank you. No questions. Thank you.
Have a good day, ma'am. I believe we have.
Okay.
I've got Amber Maldonado next. You've got someone else there, obviously, Mr. McDaniel.
They got less than 30 days.
It's Amber Maldonado.
No, this is Jerry Miller.
Oh, Jerry Miller.
That's not Amber Maldonado.
I apologize. Yeah,
Who
Jerry
do you
Miller.
have?
Jerry Miller.
How you doing, Mr. Mercer?
I look at it for paper.
All right, good to see you, Mr. Miller. Mr. Miller is here for the charge of possession, drug paraphernalia. Mr. Miller, listen to Mr. McDaniel. I'm appointing his officer to represent you, sir.
Your Honor, I talked to Mr. Miller. He's going to enter a plea of no contest. The charges listed. You understand, he'll be sentenced to 6 days in county jail, credit for 6 days, $385 fine, be adjudicated guilty. He's also going to sign his plea waiver form, waiving his right to go to Alabama, which he's already signed.
6 days, credit for 6 days. It was a baggie with allegedly tested positive for the remnants of methamphetamine, but no actual methamphetamine. I believe that's right. Mr. Mitchell, is that all agreeable with the state?
It is, Your Honor.
Mr. Miller, sir, any questions about that agreement?
Yeah, no, sir.
Mr. Goodson, do you have something on this? Mr. Miller, is this a plea you would like to enter?
Yes, sir. I put in that withheld judo. I mean, what was that I put in? The extradition, the waiver. That gives them how long? Like 30 days.
Okay, we're going to take care of the criminal charge first, and it's not a withhold because of your history. So on the criminal case, that's what you want to do, right?
Yes, sir. Yes, sir. Yes, sir.
All right. So on the criminal case, I'm going to accept your plea of no contest to the charge of possession of drug paraphernalia. The judge you guilty, sentence you to 6 days in jail, give you credit for 6 days you've served, impose court costs and fines of $385. Those will be a civil judgment. So that's over with. Then you have the waiver of extradition issue, and my understanding is you've signed the waiver of extradition. And he did that this morning, Mr. McDaniel?
Yes, Your Honor.
And Mr. Miller, they have 30 days to pick you up. 30 days starts today. But Mr. Miller, we review the cases at 15 days. So if you're still here in 15 days, you come back to first appearance, I'll say, Mr. Jailer, where do we stand on this transport? You'll get to hear that answer. You'll hear everything I hear, and you'll know where you stand. If they release that hold, if they say, hey, we've changed our mind, we're not coming to get Mr. Miller. If that were to happen, you'll be released immediately. Any questions?
Okay, awesome. No, sir. I hope that happens.
Have a good day, sir.
All right, yes, sir.
We have Amber Maldonado next. Ms. Maldonado, good morning. Ms. Maldonado, you're here in case number 21-786 CT. You're accused of violating the terms of your county probation, ma'am. I'm appointing the public defender's officer to represent you. Please listen to Mr. McDaniel, your attorney.
Your Honor, I spoke to Ms. Maldonado. She's going to admit that she violated her probation, understanding that she'll be sentenced to 60 days in the county jail, 24 days jail credit, and whatever remaining fines owed in the case.
Mr. Gibson.
She had a arrears of 978.
978.
Yes, sir.
And Mr. Mitchell, is that agreeable with the state?
It is, Your Honor.
And Ms. Maldonado, did you hear that agreement, ma'am?
Did you hear the agreement, 60 days in jail, 24 credit?
Yeah.
Ms. Maldonado, is that the plea you would like to enter?
Yes, sir.
Same as.
Ms. Maldonado, I'm going to accept your admission that you violated your probation in case 21-786 CT, revoke that probation, sentence you to 60 days in jail, but you have credit for 24 days you've already served. That means you have at most 36 days. The reason I say at most is you may do less than that under Florida game time law. I can't promise that. That's between you and the jail, but you certainly possible. 978 court costs and fines are left. If you get it worked off at the jail, that's great. If not, it'll be a civil judgment for that amount against you. Ma'am, there's no probation involved in this sentence. When you finish this sentence, you'll be released, and we have nothing else here. As long as you don't have any holds anywhere, you'll be released. Do you have any questions, Ms. Maldonado?
No, sir. Can I be a
Wish you the best, ma'am. And we have Brooke Francis. Ms. Francis, good morning. Ms. Francis, you're here. You were first appeared last week for a charge of simple battery. You also have a hold from the Dove Academy. I'm appointing the public defender's officer to represent you, ma'am. Please listen to Mr. McDaniel, your attorney.
Your Honor, I spoke to Ms. Francis. She's going to enter a plea to admit a charge of disorderly conduct, understanding she'll be sentenced to 60 days in the county jail, 6 days jail credit, $722 fine. She has waived the right to a jury trial and call witnesses, and this will resolve this case today.
Mr. Mitchell.
That is agreeable with the state, Your Honor.
And Ms. Francis, did you hear that agreement, ma'am?
Yes, sir.
Do you have any questions about that agreement?
Only if I can figure out like if I can do like work here so I can work off that because I have no job, nothing. I'm currently homeless. So.
What did you ask?
Oh, if I can just work it off.
Yeah.
That's what I was asking.
Hopefully you'll get that worked off at the jail. You will get the chance to be in the trustee program if you qualify.
370 is where the
Okay. I forgot where I was.
You'll get a chance to work it off in the trustee.
I got 3 people talking at one time. I'm sorry. I can't.
Sorry.
My wife says I can't listen to one person at a time, much less 3. So, ma'am, to answer your question, you'll get a chance to work that off at the jail. If you don't, there'll be a civil judgment against you. Hopefully you'll get it worked off before you leave the jail. Mr. Goodson made a point that the court costs and fines may be wrong. On disorderly conduct, that changes the court costs and fines from the battery court costs and fines, which it was. They're much lower. So the court costs and fines are only $370, not the other number. You have 6 days credit, ma'am, and you do have that hold from Dove Academy. So when you get near the completion of this sentence, the jail will notify them that if they still want you, and I'm assuming you're there under a commitment from a judge, a juvenile judge. So if they still want you, then they'll pick you up, ma'am, and place you wherever they think is appropriate. There were 2 ladies here yesterday because your case was originally scheduled for yesterday, and those 2 ladies were from that academy, I believe. They're not here today, Ms. Francis, but this criminal case in Jackson County is over. Do you have any questions?
No, Your Honor.
All right. Wish you the best.
Thank you, sir.
Yes, ma'am. We have Byron Polnitz. Mr. Polnitz, good morning, Mr. Polnitz. Listen to Mr. McDaniel. He's going to tell you the case number. I don't have that in front of me. He's going to tell me what we're here on in your case or cases. Mr. McDaniel.
Your Honor, we're here on 26-7 CT. That's the DUI charge, and 26-208 CT. That's driving my license suspended, revoked. Essentially the new charge of the driving license suspended, revoked. The court revoked this bond in the DUI case, and that's where we are, revoked bond. And I tried to talk to Mr. Polnitz, but I don't know if we you don't understand. I think some things.
I understand, sir.
All right, so as far as scheduling, Mr. McDaniel, what do you want to schedule Mr. Polnitz for? What court date?
July 8th, court docket, jail docket.
July 8th. Mr. Mitchell, anything from the state?
No, Your Honor.
Mr. Polnitz, do you have any questions about that, sir?
Yeah, I'm wanna know what's going on here. That's all it is. Cause see, I had my license once suspended, see what I'm saying, sir? And then they had sent me a court paper where they say I paid before my license gets suspended on May 26th, so I got my mother that paid right there. And before this case, when I got caught, my license weren't suspended prior. See what I'm saying? So they sent the paperwork saying my license was not suspended, then I can pay on May 26th. And then I had sent the money silent with my mother, Alice, and basically all this right here, that's how that had up. And then when I went to court yesterday, the guy, they was like, you ordered me right there. I came to court and y'all kept saying something about my license when I come to court. See what I'm saying?
Mr. Ponus, when you came to court, not yesterday, but the time before that, which was about 3 weeks ago,
Yeah,
according to the complaint, the officers advised you your license was suspended. You still got in the car and left that day after they advised your license was suspended. Let me finish. That's what you're accused of. They haven't convicted you of that. The allegation is they told your license was suspended. You still left. They didn't arrest you that day for whatever reason.
Yeah.
They did process the charge. So that's why you got the new charge. And then, according to what the bailiff told me, now you drove to court again yesterday, again, after you've been told your license is suspended. That's why you're in jail. Do you have questions?
But look, my license weren't suspended. When 3 weeks ago, I got straight to work to see what type of business we could get done. That's why that's what happened. Then they sent paperwork. They say pay that, and then that's why my license are valid. Now that's why that's why the confusion with the accusations, then where I was straight across right there.
Okay, let's do this. Give me a second, and I'm going to put it up on the current state of Florida system, and let's see what that current system shows right now on your license, Mr. Polnitz. Give me a second to pull it up, and let's see what the state of Florida system shows. Polnitz?
Yes.
Byron?
I can check the FLHSMV.
No, it's not coming up under that name. I wonder if it's you got to. The jail didn't add it on the list. I don't have a driver's license number.
I can look it up right quick.
Okay.
I just look it up by the number.
Yeah, I don't have the number because he's not on the first appearance list, like he should have been. It's got to be a different spelling or a middle name or something.
It's being slow, but it's looking it up right now. As of June 2nd, 2026 at 10:18 a.m., Florida driver's license number, I'm not going to put it on the record, is suspended.
Do you show how many suspensions he has? Will it show you how many different things it's suspended for?
It's just the one. It went into effect on January 3rd, 2026 as a result of the refusal charge.
So, Mr. Polnitz, according to the state of Florida's driver database, it's the same thing you were told that day by the deputies, allegedly, and that is that your license is suspended. Now, do you have any questions?
I have a question. Plus, sir, you see on January 3rd, when I got this how it all started right here, sir. And then there's an accusation come in and say where my license was suspended. So I had checked on right there. My license was suspended when I got pulled over. See what I'm saying, sir? And then when they say my license was suspended, when you know I went to court 3 weeks ago, I went to work about that, sir. I got to see about my license, knowing it was suspended. So I went to the Florida statute like that, sir. And then basically they gave me good order. They say pay that fee, $100 fee, $163 fee. So I got my mother Alice to pay the fee. They say I had to May 26th, my license to be valid through May 26th. On that January 3rd thing with that key where you told me about all that stuff, Judge, about the order, about the life right there. And then I was straight across right there, sir, doing the right thing. And then when I went to court yesterday, well, if the money didn't come through, sir, cause my mother they had sent the paperwork in. I got the paperwork.
That's enough. You're talking about stuff you need to talk to your attorney about in private. We'll see you on your next court date. Have a good day, sir.
All right.
Mr. McDaniel, I think that's it for our first appearance list and all the comebacks, the bring back cases from last week. And I certainly may have missed something. We had a lot today. Anything else from the public defender's office?
No, Your Honor.
Corporal, anything else from the jail this morning?
No, Your Honor.
An eventful morning down in Florida. We've had a pretty good morning so far, about halfway through the show. I hope you've all enjoyed it. I know I have. Good morning once again, TCF Live on this beautiful, beautiful Tuesday. So we haven't been able to go here for a while because, quite frankly, there hasn't been anything overly compelling going on, but it looks like a sentencing is about to happen. Wisconsin. Judge Mogan.
We'll go on the record in the matter 24 CF 50, State of Wisconsin versus Adam Evans. The state appears through District Attorney Kevin Schmidt in person. We have Mr. Evans appearing in person in custody with his counsel, Daniel Chapman. We're set here today in this matter for the sentencing part of this case. Mr. Evans pled guilty on March 13th to 1 count of driving or operating a vehicle without consent, a Class I felony, 1 count of burglary of a building or a dwelling as a party to a crime, a Class F felony, and 1 count of driving or operating a motor vehicle without consent, an I felony. The court ordered the pre-sentence investigation report. The court has received and reviewed the report. And I am not sure, but I think there was an error on page 11 as it relates to Mr. Evans' Polk County case 24 CF 40. I don't believe that's the correct case number.
Yeah, it must be 50.
I believe that was the only error that popped out to me when I reviewed, because I don't have as much intimate and personal information as either the state nor the defense. Mr. Schmidt, did you receive the pre-sentence investigation report?
I did. I reviewed it. I have no corrections.
Mr. Chapman?
I have it. I reviewed it with Mr. Evans. We have no corrections.
All right, thank you. And Mr. Evans, that's true. Mr. Chapman went over that with you?
Yes, ma'am.
And you could not find any material errors that needed to be corrected?
No, ma'am.
All right, thank you. We are in victims' rights compliance. We do not have any victims who are going to be making any statement today. So we'll proceed to arguments. Mr. Schmidt.
The state is going to be arguing something in the middle of the Department of Corrections recommendation. It's going to be arguing for 6 years initial confinement, followed by 4 years extended supervision, totaling a 10-year sentence on the burglary. The other counts, the state's going to recommend following DOC's recommendation to run those concurrent, and they gave various ranges for that. This recommendation is primarily driven by need to protect the public, gravity of the offense, and rehabilitative needs of the offender. As to gravity of the offense, it's really high. As the owner said in his victim impact statement, he had gone through a long time where he had not been burglarized, and then he got hit twice within a short period of time. This was the second time. He's at a loss because he still hasn't recovered everything that was lost. The nature of the offense, especially in conjunction with the criminal history, means probation would unduly depreciate the seriousness of the offense, especially with the read-ins. The version of events that Adam Evans gave in the PSI, I believe, is correct. When we did the sentencings for the other co-defendants, Charles Evans and Chantel Bentley, I spent a long time outlining all the physical evidence, all the high-tech digital things we did, and explained how it showed that both of those people, when they gave their version of events in the PSI, gave things that were plainly contradicted by the physical evidence. And I argued that was evidence that those two individuals were denying responsibility for it. The account that Adam Evans gave is the account that law enforcement believes fits the evidence. Both Charles and Chantel denied responsibility for entering the black and orange and claimed they were sitting out in the vehicle. So all three people claim that, despite the fact that footprint evidence showed Charles did go in, and the two people who went in were tall, and Mr. Evans has a much broader frame than both of them, and he obviously was not the person in there. So to that extent, that's something that weighs in Evans' favor. He's owning up to what he did. He's actually telling the truth about what happened, and he is coming to the court and accepting responsibility in a way that the other two co-defendants did not. On the other side of the coin, the main aggravating factor in this case that bleeds into the gravity offense, the need to protect the public, and rehabilitative needs is the fact that he did this with his high school age son. There are numerous red flashing signs across a lot of the evidence, namely like the messages and whatnot, that Charles Evans loves his dad and wants to be like his dad and follows him in many ways, for better or for worse. Whatever Adam does, Charles will follow. We talk a lot in this courtroom about the awesome responsibility that parents have to guide their children. It's not just the things we tell them to do or do with them, but the model we set ourselves for them. Adam's youth in the PSI involved some early thievery, along with consistent substance abuse over a long period of time that crescendoed into that federal prison sentence for a drug conspiracy. That sentence robbed Charles of his father for many years. When Adam got out of prison, he starts doing this thievery type stuff with his son. He puts his son on the same path he took when he was Charles's age. And sure enough, while Charles is out on bond in his part of this case, he gets arrested for selling drugs. The same behavior that landed his father in prison, the same behavior that Adam describes his father, Roger Evans, having problems with. And now we have a chain of behavior stretching 3 generations of men in the Evans family, from Roger's Mexican cartel activities to Adam's federal drug conspiracy to Charles selling THC, the consistent trend of the thievery-related activities from Adam to Charles that he says is connected to the drug use, even though Adam says that his father, Roger, wasn't involved in thievery and said things like, "I don't like thievery," and that was part of his motivation for getting into it. I lay this all out here because this is why family stability, attitudes, and values is in the PSI, why it's a category. These are things that are predictive of the future should no intervention occur. It sure seems like Charles Evans is still influenceable by his father. His father took the skills that it's documented he learned in federal prison, and I suspect it's skills that also built into the employment he was able to procure as well, and applied that to his son, taught his son skills, took his son on that path, his son would likely follow. The chain of generational crime could stop with Adam and Charles, and thus the community would be protected in the future from crime from either of them. The problem is that it sure looks like instead it was a different skill set that Adam imparted onto his son, or at least taught him for this offense. And that is problematic. Thus, there's a need for specific deterrence of Charles Evans, not just for the offense that he committed of the burglary, but who he did it with and who was obviously learning from him and Chantel Bentley. He always had the chance at a bare minimum to keep his son out of this lifestyle. You go beyond that, another problem we look at with Mr. Evans that I think is aggravating is his history and his adjustment on supervision. Adam Evans has not made significant gains while on probation. The probationary periods, when you look at the PSI, they've always known there's been an AOD issue and it's never been tackled. The gains they document him making in federal prison, however, have been extraordinary. He got a lot of specific training there. He got his HSED well in there. He did extremely well in a confined setting. Thus, there's good evidence that he succeeds best in a confined setting. And we know, since he says that the driving force of the burglary here was the substance abuse, and the read-in involves him being in a vehicle with Leanna DeMars Huser, who had a large amount of meth. You know, that's a present issue. That's something he still grapples with. You never beat addiction. You only ever control it or deal with it. And right now he's not dealing with it, and he needs treatment. And a confined setting is where we see he's done best at that. The duration of the prison sentence should be tailored towards the high end because of the criminal history and because of the aggravating fact that he's laying the path for his son to do the same behavior in the future. It harms the community and to a greater extent harms his son. Seeing a stiff sentence might be something that would specifically deter Charles Evans from continuing that path in addiction and in terms of doing the thievery style offenses, in addition to the general deterrence of the public. We talk, when we say general deterrence, you know, there's two types of deterrence. There's general deterrence and there's specific deterrence. There's specifically deterring this offender, and then there's general deterrence of the public. We can actually see a real general deterrent effect here because we can pick a person out from the general public and see how a higher sentence here would be conveying a message to that person, don't follow that path. So there's a much higher general deterrent effect in this case than we normally see. The court should also incentivize Adam Evans to participate in programming in prison by making him eligible for CIP and SAP. Like I said, part of the reason why a confined sentence is appropriate for him is because he does well there. So he should be incentivized to do those. Just like the feds did. And the feds incentivized him to make himself better, and he did. He did a lot of things to improve himself in federal prison. I think there's a lot of reason to believe that he might do so again in state prison. I just think the court should stagger it so that he can't get the benefits of the program initially. That is, it should set a period by which he's allowed to take advantage of the release portion of it. Not staggering it until he can't start it until a certain time, but the release portion, because we want him to start it as soon as possible. I would suggest something in the 3 to 4 year range of that, because there is a need for actual punishment in this case, because of the gravity of the offense for the reasons I outlined before, and also for the general and specific deterrent effects. So to sum up, the defendant obviously has rehabilitative needs. There's a long documented history of AODA issues with Adam Evans. There's also a long documented history of thievery related things, because when you look at his early history, stealing that stuff, these concerns are best addressed in a confined setting because of the lack of success on supervision previously, and because there just is a need for punishment here as well. Furthermore, the history is aggravating because of the aforementioned pattern of stealing. Thus, there's a greater need for that specific deterrence for this offender. We can't do the same things over and over and expect different results. Additionally, the defendant bringing his son into his criminal enterprises and the trends we've seen from his son has been disconcerting. Adam Evans got a lot of skills in federal prison. He could very easily use those skills to be a good model for his son. Instead, he's imparted the bad skills that he knows to his son. That fact in particular lends towards general deterrence and lends towards a higher sentence. We need to deter both Charles Evans and we need to deter both Adam Evans and the general public, which includes Charles Evans. Thank you.
Thank you. Mr. Chapman? First off, before I ask for your argument and recommendation from you, is there a stipulation to the restitution of $13,840.95?
Mr. Evans would like a restitution hearing on that, Your Honor.
Okay. So
that
it's
was
not
part of the offer that he stipulated to that, though.
That's stipulated to the amount.
Yeah, stipulate to
I
restitution.
thought that was, that's why I wrote it down.
Do we have the plea questionnaire? Because I actually looked for that on this exact issue and couldn't find it.
I don't have it. We've looked. And it's not in the electronic file. Any ones that I would have kept up and accidentally not provided would be up here. And the only one I have is a Jeffrey Bloom. So why don't we'll just take a little bit of time. 5 minutes enough, or do you want 10?
5 is probably fine. Can I step out into the hallway with Mr. Evans?
No, you may not. We will all vacate except for the officer.
Okay, friends, we will rotate back there then at some point, because obviously they're taking a bit of a break, but I'd like to see the end of that. In the meantime, let's do this. Let's go down to Texas, and we will check in this morning with Judge West.
Victoria, This is cause numbers 21-36410 and 21-36411. Mr. Victoria is charged with murder in each of those cases. And what is the announcement?
We have filled out a plea bargaining rejection form, in each of these cases.
All right, give me just a second. So what that means, Mr. Victoria, in each of your cases is that if you go to trial and you're found guilty, the range of punishment, I'm sorry, it's going slow.
It's habitual.
So your indictment alleges, in each of those cases, in addition to the charge of murder, it alleges that you were previously convicted of aggravated robbery, burglary of a habitation, retaliation, and another burglary of a habitation, and an aggravated robbery. All those are from the same date.
There's also a federal conviction.
I'm sorry, can you hear me?
So a federal conviction, he is habitual.
Okay. And so in your indictment, it alleges that you were previously convicted of all of those prior felonies. In addition, it sounds like there is a federal conviction that was after that, which would make you, for punishment purposes, if you're found guilty and those prior convictions are true, a habitual offender with a minimum punishment of 25 years if you're found guilty, up to 99 years or life in prison in each of those cases. Do you understand?
Yes, ma'am.
And in each of those cases, I have here on the tablet some documents that you've signed with Mr. Eckhart that show that the district attorney's office has made offers in your cases if you wanted to enter pleas of guilty for 35-year terms in each of those cases that would run concurrently, which means together at the same time. You have every right to reject that and have your cases set for trial. I just want to make sure you understand what the possible consequences are if you go to trial, what your options are. Do you understand all that?
Yes, ma'am.
And do you want to reject those offers and have your cases set for trial?
Yes, ma'am.
All right. And is there any reason to believe that there would be a change or in that offer? Anything that you guys are waiting on evidence or discovery wise?
There's going to be some things that I'm going to ask Philip to request, but nothing that I think we're waiting on. Just it's not in the file, but we're working on it.
Okay. I just want to make sure when we get to that trial date, obviously, the age of this case is very concerning. So I want to, once it's on the trial docket, it's going to be expected to move pretty quickly. So if y'all need anything, make sure you make those requests quickly so that when it gets to trial, we'll get that taken care of. Also want to make sure you understand, sir, that after today, I will not accept this plea agreement. If anything changes, something comes up, the attorneys don't know now, then maybe that would be different, but otherwise it's going to be a trial, or if you change your mind, you can enter an open plea or to something different. You understand?
Yes, ma'am.
All right, we can go back with the bailiff. We'll get it in the trial docket.
Thank you, Judge.
Yes, sir. Mr. Macon, you've got Brian McQuaid. Good morning. Good morning.
Good morning, Your Honor. Did he win to now? Yeah. It's a long story. I'll share it.
To the courtroom?
You missed the excitement this morning.
I did.
I was next door in the interview room, went to slide back and fell off the stool and my legs were caught and I couldn't stand up. So I called out, help, help. And the deputies go, what do you need? I went, help. They opened the door. And,
oh my God.
Oh, yeah.
I'm glad you're okay.
Yeah.
Good morning. Are you Brian McQuaid?
Yes, ma'am.
And this is 26 DCCR 0402. Mr. McQuaid is charged with aggravated assault with a deadly weapon. And what is the announcement?
Your Honor, he's rejecting the offer of 10 years, probated for 10 years.
Did you do a plea bargain rejection?
Yeah.
Oh, can you do it on the tablet? Where'd you find that? Yeah.
I didn't know there would be a test.
I'm sorry. I didn't know we had still paper stuff out there. We should. It's on the tablet. Can you do it on the tablet real quick? Thank you. I'll take care of it as soon as y'all do that. Just after docket, let's go look at what else out there. Ms. Perazzo, you have Ava Musgrove. Ava.
Good morning, Your Honor.
Good morning, sir. How are you?
I'm good. Go for it.
It's a little early. Good morning, you're Ava Musgrove? Yes, Sean. And this is 25 DCCR 0048. Ms. Musgrove's case is set for trial to begin with jury selection next Monday. And what is the announcement?
So, Your Honor, I have become aware of some medical records that I am needing to request that pertain to Ms. Musgrove.
Okay.
And without knowing, well, because I wasn't aware of them until I received a report.
Okay.
And I just have to be kind of careful.
Sure.
About.
Did y'all file a motion for continuance?
No, ma'am, we did not, and I apologize.
Mr. Nichols?
State's ready, Your Honor, to understand whatever concerns Mr. Rosen may have.
So old. So what I'll do is reset it to the next trial docket. Whatever needs to take place has to take place before that. There won't be another reset.
Yes, ma'am.
Okay, thank you.
Thank you.
You can go back with the baby. Mr. Adams, you've got Travis Smith.
Yeah, yes, I think we're ready.
Good morning.
Morning.
Do you have your discovery certification?
No. See, let me see.
Yeah, I think it's a couple.
I gotta do this.
So it's just. Actually.
Yes, ma'am. And you'll need to email the attachment today to the clerk. It has to be here today. Yes, got it. Yes, ma'am. Thank you. All right, so you're Travis Smith? Okay, thank you. And so I'm going to take judicial notice of the court's file. And Mr. Smith was previously found not competent to stand trial, was sent to the John Dunn Behavioral Science Center for Competency Restoration. I received the report back from that facility. There is the forensic psychiatry report prepared by Dr. Select, dated May 13th of 2026, with the finding that Mr. Smith is currently competent to stand trial. In addition to that, there's a trial competency evaluation report prepared by Dr. Guzman, also with the opinion that Mr. Smith has regained a competency to stand trial. Is there any other evidence with regard to competency?
Not at this time, Your Honor. I've got the report.
All right, then at this time, I am going to find Mr. Smith competent to stand trial. Will he waive the formal reading of the indictment?
We'll waive, John.
Mr. Smith, in cause number 25 BCCR 1251, you're charged with the state jail felony offense of theft with previous theft convictions from August 14th of 2025. The indictment alleges you were previously convicted of theft July 29th of 2014. And then after that, December 16th of 2014. And how do you plead to that charge? And are those prior convictions true? Are the prior convictions true?
Yeah.
And did you enter your plea of guilty and true freely and voluntarily? And did you plead guilty because you actually did what they charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Adams?
Yes.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes.
And it looks like the agreement that you've reached.
2 years probated, fine with $1,000.
Okay, y'all filled out the 2 years state jail and 2 years county jail.
Yeah,
State-
I couldn't erase it I was gonna erase the county jail. I'm not sure which would be,
Okay.
but
All right, so it looks like the agreement that you've reached is for a 2-year term in the state jail prison, but that would be probated. You'd be on probation for 5 years. You would be ordered to pay a $1,000 fine to follow all of the rules and conditions of probation, including being on the mental health caseload. So we'll give you everything you need in order to be successful. Is that your understanding? Do you also, and it looks like also that the state's going to dismiss a misdemeanor harassment charge in cause number 25 CCCR 1, is that a 1 or a 7?
it's 1688.
Thank you. 1688. It's your understanding that's going to be dismissed. Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1.
No objection.
It's admitted. Mr. Smith, I'm going to find again that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and that you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. Do I need a pre-sentence report? Is there?
Please, Judge.
Okay.
I think with
So-
the mental health issues.
Yeah, he's gonna have some special issues.
Sure. So I'm going to reset. I'm going to reset your case so that the probation department can do a pre-sentence report. That'll just give me more information about you, your case, your history, what all you might need while you're on probation, and then we'll come back later for sentencing. Okay. All right. We'll see y'all at sentencing. Is the Ms. Coffin? You've got Jesse Griffin. Good morning. It's a very pretty suit. Good morning.
Just an FYI, while we're waiting for that defendant, we still have not seen Judge Mogan return to her court. So that attorney is apparently still talking with the defendant, but I've got an eye out.
Good morning, sir. You're Jesse Griffin. And this is cause number 25 DCCR 1397. Mr. Griffin is charged with aggravated assault with a deadly weapon. I'm going to take judicial notice of the court's file. Looks like Mr. Griffin was evaluated for competency to stand trial. Received that report from Dr. Papon dated April 15th of 2026 with the finding that Mr. Griffin is currently competent to stand trial. Any other evidence with regard to competency?
No, Your Honor.
No, Your Honor.
All right, then I am going to find at this time Mr. Griffin is competent to stand trial. And what is the announcement?
No.
Yes.
Your Honor, he still would like to proceed to a jury trial.
All right, so it looks like there was a plea bargain rejection in January where the offer was for 8 years. Is there any change in that offer or negotiations?
No.
So, Mr. Griffin, you still want to reject that and have your case set for trial?
Yes, ma'am.
All right, we'll get you moved to the trial docket, and Ms. Coffin will begin preparation for trial. I do want to make sure you understand that after today, I will not accept this plea agreement unless some new information that comes to light that the attorneys don't know. If you change your mind later, want to enter a plea of guilty, it could be open to the court or to some different plea agreement, but not this. You understand?
Yes, ma'am.
All right, you can go back with the bailiff.
Thank you.
Your Honor.
Yes, ma'am. See, is there a Miss Bosley here? Okay. Mr. Parker, you've got Terrence Alexander. Terrence Alexander. Good morning, sir. Are you Terrence Alexander? And will your client waive the formal reading of the indictment?
You will, Your Honor.
We're going on count one only. Mr. Alexander, in cause number 22-40966, the state has elected to proceed on count one only. It alleges that you committed the state jail felony offense of criminal mischief from July 21st of 2022. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Alexander is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent. You understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of criminal mischief. Sentence you in accordance with that agreement that you made to a term of 18 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows that this was an agreement that I followed, and so you have waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, how long that lasts, you can talk with Mr. Parker. Good luck to you, sir. You go back with the bailiff.
Can I get a paper that shows like my back time?
They're going to have to figure that out after court, and it'll be in your judgment and sent over to the jail probably this afternoon or tomorrow.
You know, get all your I've already.
I just said you get all your credit that you're legally entitled to. All right, thank you. Victor Perez, Mr. Parker.
Pleading out for bill number 2.
We'll ban and count to Your Honor.
Good morning, sir. Are you Victor Perez?
Yes.
And Mr. Parker, will your client waive a formal reading of the motion?
It will.
Mr. Perez, in cause number 17-26788, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation January 8th of 2018 for the 3rd-degree felony offense of assault on a public servant. and that was a 10-year deferred probation. Is that correct?
Yes, ma'am.
This motion alleges that you violated your probation in count 1 by committing the new offense of driving while intoxicated, November 22nd, 2025 in Hidalgo County, Texas. And is that true or not true?
True.
And then the state's going to abandon 2, correct?
Yes, Your Honor.
Count 3 alleges that you were at a location other than your residence, November 22nd of 2025 at approximately 2:08 a.m. And is that true or not true?
True.
Count 4 alleges that you failed to report for the administrative hearing on October 6th of 2025. And is that true or not true? Count 5 alleges that you failed to report by mail or online to the Jefferson County Probation Department for February, March, May, June, August, September, October, November, and December of 2022, January through December of 2023, January, March, June, July, August, September, October, and December of 2024, and then January through December of 2025. And is that true or not true?
True.
We can drop their many counts.
All right, sir, did you enter your pleas of true to counts 1, 3, 4, and 5 freely and voluntarily? And did you plead true to those counts because they're actually true?
Yes.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with Mr. Parker?
Yes.
Do you fully understand that?
Yes.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes.
State tenders number 1. Freely and voluntarily, find those counts true, find sufficient evidence at this time to find you guilty, and at this time find you guilty of the lesser offense of the 3rd-degree felony assault on a public servant, sentence you in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification. That shows that this was an agreement that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right, good luck to you, sir. You can go back with the bailiff.
Alrighty, friends, TCF Live on this fine Tuesday, hour number 3 now. Time is flying, but we're having some good court today. Let's head back up to Wisconsin and Judge Mogan. We left her a while back as the defense attorney and the defendant were going to have a conversation in the middle of the sentencing, but they are back, so let's continue with that hearing.
Previously noted, the court allowed Mr. Evans to have a confidential conference with his client. The court also then permitted Mr. Evans to go up to his, or over to his jail cell to look through his paperwork to see if he had that copy of the plea questionnaire waiver of rights form. He indicated he could not find a copy. Is that correct, Mr. Evans?
Yes, ma'am.
Okay, thank you for looking.
Yeah.
Okay, Mr. Chapman, as it relates to, I guess, that matter, that issue.
Your Honor, I could tell from my notes that in discussions over the plea resolution, I had just written down restitution, and it wasn't clear whether that was stipulates to the 13,000 or whatever is in the restitution request, which I believe I hadn't even received at that time, or whether it was we agree that he's joint and severally responsible for restitution. In any case, the remedy would not be that the court has to agree with us. The remedy would be if there's no meeting of the minds, the plea would be undone, and Mr. Evans does not want that. He is willing to stipulate to the amount requested by the state.
All right, thank you. So he is going to request or stipulate to $13,840.95 joint and severally liable with all co-defendants.
Yes.
All right. Okay, thank you. Now let's move on. Mr. Chapman, argument and sentencing recommendation, please.
Your Honor, I don't believe that the state and I are too far off in our requests. I agree that a prison sentence imposed at this time is an appropriate resolution. I think we're just arguing about the amount. I disagree that 6 years is necessary under the circumstances, and instead I'm going to ask the court to impose an initial confinement portion of 4 years, possibly with a lengthier portion of extended supervision. I have concerns about the state's reliance on an aggravated factor of Charles's behavior. If this was a case where Charles was 14 and was the mitigated participant and was the one in the car while his father was committing crimes, that would be one thing. But I think we all agree that Charles was actually a more active participant in this crime than Adam was. So it almost feels to me like that argument is asking the courts to punish Mr. Evans for prior bad influence on Charles that led him to this day. And honestly, given the statements of all the parties to law enforcement and given what we know about Chantel's phone records and the fact that she was the one attempting to sell various items that were stolen, I think Mr. Evans' version to the PSI author that this whole burglary of the Black and Orange was Chantel's idea because she had a specific grievance against that place due to her sister is plausible. And while yes, it says something about Mr. Evans's skills as a father that he did not step in and say, no, son, you shouldn't do this. I think it was Chantel that was the one that was the brains behind the Black and Orange burglary. And Mr. Evans, well, Adam Evans is the bad parenting in this situation was not saying no, not that Adam Evans specifically led Charles Evans to this conduct. I think Charles Evans at this point is an adult and made his own decision. And in fact, as the person in the bar was the more culpable party. So to then argue that this is an aggravated factor against Adam Evans because he's committing crimes with his son, I don't think he was a bad influence here. I think Charles made his own decision in this case, Judge. So yes, he could have been a better father leading up to it, but I don't think the prior examples of being a bad parent should be treated as an aggravated factor in this particular case. As far as the actual seriousness of the crimes, Judge, while yes, burglary is specifically a serious crime in and of itself, the maximum penalty for burglary for initial confinement is 7.5 years. And simply based on the facts of the case where Adam Evans was the party who was waiting in the car, I think that puts him specifically in a mitigated role in this case, which does not call for an aggravated sentence. I think 4 years is a sufficient penalty for a burglary to a bar where a person has a mitigated role in that burglary as party to a crime. And given Mr. Evans's record, I think that takes it into account. Otherwise, I'd be here asking for probation. Mr. Evans obviously does have a record, but almost all of that was focused on approximately 1 year in 2015, I believe, 2014, 2015. He had a possession of meth charge, he had a bail jumping charge, and he had the federal conspiracy case, which ultimately led to 5 years of prison. But prior to that, he didn't even have a felony record. He had, as the state indicated, some thefts early in his record. He had a disorderly conduct, and then he went to prison. And he got out of prison, and yes, as the state indicated, he did very well in prison. He also did very well on supervision. He had about 4 years there that's described in the PSI where he was sober, he was working, he had his own residence, he had his own vehicle, he had regained full custody of his son, which is very difficult for a man to do, especially with a criminal record. Everything was going fine until things went bad with his significant other. And he left his house, he left his significant other, he left his son, and he went back to using. And now here we are, a burglary charge, the operating a motor vehicle charges. I would just point out, Mr. Evans tells me he wasn't even there when they were stolen, but he did assist Miss Bentley in disposing of them. She was attempting to sell them online. She didn't. And then he helped her take the vehicles to the scrap yard and used his ID to scrap them. They didn't even work, but he put them on a trailer, which involved operating, and he knew he didn't have consent. And the meth charge in Buffalo County, which state didn't say too much about it. I'm not going to say too much about it either. If Buffalo County doesn't consider it that serious, that they just wanted it dismissed and read in with our case, I'd ask the court not to put too much of an aggravating factor on that. But yes, he was in possession of, I believe, about 13 grams of methamphetamine, which is a lot. I asked him why it was all in his vehicle at that time. He said he didn't have anywhere else to live at that time. So all of his possessions were in the vehicle at that time. I believe if the court imposes a prison sentence, the 4 years that I'm asking for, he has significant credit at this point.
What is the credit?
I believe 574 days, not including today. He's been confined consistently since December 11th of 2024. He's been an inmate worker almost that entire time here at the Burnett County Jail. That would still leave enough time that he would be allowed to, and he'd be incentivized to participate in the substance abuse program, which I agree is what's best for Mr. Evans at this time. I don't believe that treatment would be provided in the community, and I think he'd be too tempted in this area to go back to using if he were in Arbor Place or Salvation Army or something like that. But I think if he goes to prison, if he does the substance abuse program and he's released to extended supervision, every indication is that a significant period of sobriety before he's released and released to the structured supervision of extended supervision, I believe he will do just as well as he did last time he was released from prison. He has employment available to him. He's got skills. I submitted a letter from his former employer. He would be happy to have him back. He's got support in the community from his family. Ms. Jensen, who also submitted a letter, has been involved talking to me about his defense, his family, what's going to happen to him when he gets out, treatment that she believes that he needs before he's released from custody. So I do think that when he gets out to extended supervision, that will be an additional structure to him beyond just going to prison where he needs treatment in a confined setting. So given the fact that he successfully completed his federal supervision for 4 years last time, I think if the court were to impose, say, 5 years of extended supervision on this one, there's every indication that Mr. Evans will return to his sober lifestyle and the public will be protected. So I would ask the court to impose a sentence of 4 years of initial confinement, 5 years of extended supervision, and then concurrent time on the operating without owner's consent charges.
Thank you. And for the record, I have read the letter from Mr. Trenter as well as Ms. Jensen's. Mr. Evans, I'm now going to turn to you to see if there's anything you would like the court to know, you want me to know about yourself. Yes.
I'm sorry. I just realized I forgot to mention that during the time that Mr. Evans has been in custody, he has also participated in both substance abuse programming as the relapse prevention program here in the jail and to various programming involving parenting and community relationships, social values, recovery maintenance. He's provided with several certificates that he's obtained in the jail.
All right. Would you like those in the court file?
Yes, please.
All right.
Elizabeth Court.
These are all.
All right. We'll make sure that these are for sure filed. Want them back.
She'll make a copy so she can give you the originals back.
What happens is she'll scan it, put it in the electronic file, and otherwise we throw it away, or I can save them and have them sent back.
I'll take them back.
Okay, so, and you're done? Okay, so,
Thank you.
Oh, do you mind if they're stamped and say?
No, that's
exhibit?
fine.
Yeah, just go ahead and stamp it. So then we'll make sure that you get them back, okay?
All right, thank you.
I'm gonna wait until she's done, then I'll go.
And there was also, like, I did do another drug, one Stop the Chaos, but, well, Burnett County came and got me before I actually received the certificate there. And I was in another parenting class that I was in for about 3 weeks and an anger management class too, but it was a 6-week thing and I got taken out of that jail before I could finish.
Where were you housed?
Buffalo County.
Buffalo?
And
Sounds like they have some really good programs.
they do, and they don't offer nothing like that here, you know. But
Well, we're just starting and getting up with a new jail. We're trying to build more programs. You know, that could be something that you want to focus on, you know, and while you're incarcerated, if you're going to be incarcerated, and, you know, think of some things and try and help this jail out.
I mentioned it because it was all through Zoom and it's all through the University of Madison.
You know what I would like? Maybe you could write down those things and you can give it to your attorney, or you can just send it down through jail mail. And then to me, so I have it, because then I can speak with our sheriff and, you know, our jail captain, and I'll look into the programs.
All right, thank you.
Okay. I would appreciate that. So now, Mr. Evans, is there anything you want to tell me about yourself, about your history, about these charges, these convictions, about the victims, about anything that you feel that you want me to know, to correct anything that you heard that was said by the state or by your attorney? You have the floor.
I actually have a lot to say, but
You have time.
so growing up was pretty wild. You know, I watched my parents get robbed at gunpoint for drugs. People in the house getting pistol whipped when I was about 7 to 8. You know, I was standing there crying in the doorway while I was watching this, and I can recall looking on the wall, and my dad had a 22 that didn't work, and I thought about grabbing. I had enough awareness at that time as a child to know not to do that, but I also had a phone in that bedroom, and I also was aware that there was illegal stuff going on. So I didn't call the cops because I didn't want my parents to get in trouble, you know. There's a lot of trauma from back then, a lot of crazy stuff that you might not even believe, but yes.
I've heard a lot and I believe a lot.
So we moved to Wisconsin. One day we packed up everything that we could in a U-Haul, came to Wisconsin. My dad told me that the cartel was gonna kill our whole family, you know. I grew up really fast right then. We had guns in every room, for bullets for every gun. He taught me how to use them safely, but he told me that these people are coming to kill your family and I need you to be a man. And if that happens, help, you know. And not just that, I mean, there was lots of abuse with my mother.
I read about all of the people that she dated and those types of things too.
I don't know, like it almost sounds like my dad was a monster, but really he wasn't. Like there was a lot of bad influences, but really he was a wonderful father in a sense, and he was my world, you know.
Well, perhaps I messed that up. It was with your father. I thought that your mother had dated people that were abusive.
No.
Okay, then sorry, I confused that
okay.
part with the abuse allegations. Yeah.
Yeah, no, my dad abused my mother quite frequently in the beginning until, I don't know, until like the last 8 years he was alive. He never touched her again after he went to a domestic abuse class. But I witnessed all that. I witnessed the
police officers slamming him to the ground in a mud puddle because they wanted him to lay down after a domestic abuse, kneeing him in the back of the head, in the back. And I actually started trying to push the officers off of him because they were hurt. He was hurting my dad. You know what I mean? Growing up, there was a lot of illegal things that was just everyday life. You know what I mean? I was introduced to a lot of drugs when I was young. A lot of illegal activities, big and small, you know. But really where I went down a horrible path is when my father died. So he was at the University of Minnesota for a month with heart issues. He had heart issues for most of his life. And when he came home, he told me he was going to be all right, but he was telling my sister and my mother all night that he came home to die, but he never told me. He did ask me if I wanted to sleep with him that night because that's how our relationship was. Like we would cuddle, like he would. It was just really hands-on love, you know what I mean? Besides all the craziness, but
Did he ever hurt you or your siblings?
I mean, I got whooped a couple times, but he never really abused me. His word was boss, you know what I mean? And a lot of things that I probably should have been in trouble for, I did with him. So there wasn't really a whole, and I knew not to do other things, you know, I don't know. But yeah, he wanted me to cuddle with him that night. And I just told him I was going to sleep with my son's mother and my son. And I wish I could take that back because the next day he had a massive heart attack in our living room. And I tried to bring him back and I couldn't. And that really set my world upside down. And I acted out. And I did a lot of bad things that I'm not proud of. But we'll skip to the federal sentence. Through all of that, prison wasn't easy. I was sent all the way to Beaumont, Texas. Never seen my family the whole time I was there. I was in there, people were getting smashed out the yard. 4 or 5 people would jump on people that had bad paperwork or told or child molesters or owed money or all kinds of crazy stuff. Stabbings, you know. About 45 days before I was supposed to go to the halfway house, there was an issue with one of the white dudes who was really high on K2 and was out of his mind. And there was 3. No, it's like
synthetic THC.
Yeah.
15, 20 years ago.
Thank you. Okay.
And there was 3 Mexicans that were going to jump him. So I grabbed him and brought him upstairs to get him out of that situation. And then the next thing you know, there was 30 to 40 Mexicans that came all the way around the tier and up the stairs and surrounded us. You know what I mean? We got locked down. It was gonna be a race riot because that's just how it is, you know, in federal prison. Like the white people have to stick with the white people. Like I couldn't even sell with a black person or they would smash me off the yard. Like it was pretty hectic in there. Also, I was there for the hurricane. They left us in a cell with no AC going because of the power being out, and it was just the backup generators with my roomie at 100 degrees, and we had to defecate in the toilet for a week without it being flushed. I sat in there smelling another man's feces and mine for a week before they let us flush it. One day, and then we had to sit on ours for another 3 days. So then after that, when it was flushed, I got the idea that we would just go to the bathroom in a trash can with a garbage bag so we could seal up the garbage bag and we wouldn't have to smell it. I think that's pretty crazy that they would just leave us in a cell going through all that. So you know, and then on the whole race riot thing, we got locked down, and when I got into my cell, all you could hear is people sharpening knives, sharpening things to use as pokers for when we came out. Luckily, we were locked down for 30 days, so it kind of de-escalated everything, you know what I mean? But that was pretty traumatizing too, you know. But when I got out of prison, I did really well. I had goals. You know, I wanted to get full-time employment. I wanted to get my own place. I wanted to get a car. I wanted to get my child back. So I saved up enough money in the halfway house, paid first last month and damage deposit on a 2-bedroom house because my goal was to get my son. And I did that. I worked at that job for 4 years and it really helped. And the farming center really helped me because it helped me get on my feet and establish something and have money to do that, you know. Then I bought my own house. That was another goal. So during all of that, I would grow a garden. Like I showed, he says that like my parenting was horrible. You know what I mean? I do agree there was some bad choices for sure, and that I don't want my son going through that, but I can't take it back now. But we would hunt, fish, process our own meat, make breakfast sausage, Italian sausage. We shot 13 deer with the bow. You know what I mean? We fished, we made smoked fish, we made jerky. Like I said, we had a 20 by 25 garden, and that was just for the main stuff. We had another one for peppers. We had the vine plants in another section. You know what I mean? We pickled. I taught them a lot of good things. We also found the time to go trail riding on our horses. We had 6 to 10 horses at any given time. We'd go trail riding for weekends. We would go fishing. We'd go camping. Up until, when I abandoned all that because I didn't know what to do, fight or flight, you know, I wasn't really ever taught. Like when I went to prison, I didn't want to do drugs. I hated them because it ruined my life. But I didn't really realize that my real issue is everything that goes on. I try to mask everything and I try not to deal with it. And you can't run away from everything because you have to deal with things, because this is what happens. You know, I needed tools for that and I never got tools for that. The only time I was really in treatment was at the farming center, but I wasn't really there for treatment. I was there for reintegrating into the community. You know, I did have goal plans. I don't know. What I'm trying to say is that everything I did, I wasn't just being a horrible father to him. I did teach him a lot of good skills and a lot of good things and do a lot of fun things that my father also taught me along with the bad. I do agree that I may not have been a great influence. And the first time I got to go to group with my son in here, I cried like a little baby in front of 8 different men because I'm sitting in a room with my child that used to be my baby. You know what I mean?
Sitting in jail with your child.
Yeah, in a room in jail, and we're both in orange. That's not cool. I understand that. Trust me, I don't want this for him. And at that point, I couldn't even tell him, you know, like how proud I was of him of graduating. And because not only was I in jail, but I had a no contact for 25 months with my only son and couldn't talk to him. So even when he was doing good, I couldn't encourage him. I couldn't be there for his graduation, which was a big deal. He worked his whole life for that. You know what I mean? And not only was I not there for that, but at prison and before prison, because I was selling drugs. I didn't want him around that. So I missed out on time then. You know what I mean? But I tried to.
Please don't bring your son deeper. Please don't.
I don't plan on it. Like I got to encourage him after you made it to where I could talk. I sent you that letter and you amended stuff, and I got to encourage him that this is where it needs to end. I don't want his son or his daughter here. I don't want him here. I want him to do good. He's better than this. Like I know that there was a lot of good things said about him at court too, and I feel like regardless of what I've done, I've instilled some of them good things in him too. You know what I mean? Not everything I've showed him is bad, you know what I mean? But I do agree that this is horrible. I don't want to be defined as this though, and I am gonna do better and I am gonna kick this habit.
Tell me about the burglaries. And I'm gonna tell you, when the warrant was done, there was suspicion that you were engaged in other burglaries. You're not gonna be charged with those. That's not the thing. But tell me about what you did here and why. You were doing good.
Because I left my house, the ex, there was abuse going on there with her to me, and I didn't want my son around that.
How did you get with Chantel, who happens to be your son's aunt?
Because I was doing drugs at that point and I was on a downward spiral.
Did you do the drugs in front of your son?
No, that's one thing that I have smoked marijuana with him. But,
Not good.
oh, I know, and I've drank with him, but I never did no hard drugs with him or in front of him. That's one thing I would not do.
So tell me about why you were convicted. Tell me about this crime.
It just came up mutually and I allowed it to happen. You know what I mean? I don't really know what to say. I wasn't in my right state of mind, and if I wouldn't have been using, I would have never allowed it to happen. And I even knew that it was wrong, but at the time, I just let it happen. You know, I wasn't thinking clearly
How did Charles get involved?
because he was around. You know what I mean? He was my best friend, kinda. You know.
Best friend in crime?
Well, not. Well, I mean, crime happened, yes, obviously, but he was my friend.
Where's your remorse? I hear your remorse with teaching your son bad things and engaging him in criminal activity. Where's your remorse for what your actions, your conduct as a party to a crime, still involved as a party to a crime? Do you have remorse for the victims?
Of course.
Tell me about it.
I have a lot of remorse. You know, I've been locked up for long time, and I think about it every night, every day, all of this. You know what I mean? Last night I probably slept 2 hours, and I probably had 7 hours in the last 3 nights. But I think about what I've done to these people and to my son all the time.
What did you do to these people?
I took things from them. I made them feel like they're not safe. Their property's not safe. You know, I've probably damaged it.
You have
They're-
anything to say to them?
Yeah,
What?
that I'm sorry. I didn't mean for this to happen. If I could change it, I
You
would.
meant for it to happen. But,
You know what I mean?
yes. But if you could go back and change things, you would do it differently.
Yeah.
Do you have any remorse for your sister, Ms.
Yep.
Jensen, who put up $15,000 for you and you fled?
Yep.
She could have taken it all.
I know.
She could have lost her house.
I know. That's another list of things to add to my issues.
And yet she's still, I'm thinking this is, no, you're not? Okay. Well, she still sent a letter and said all kinds of good things.
She's sick this morning, ma'am.
Who
Otherwise,
else is here?
my cousin Tony and his significant other and my boss or my friend, longtime friend and
One with the letter?
ex-boss. Yeah.
Excellent. Love tree guys. They're great. Costs a lot of money to remove a tree, but hey, heck.
Depends, yeah.
Yeah, it depends. Where are you located? Webster? Great to know. All right. Anything else you want to let me know?
I'd just like to take the time to apologize to them and my family, the community, and the victims and the courts. Thank you for this time.
Thank you, Mr. Evans. I apologize if my voice is going up and down and whatever. I don't know what's happening with it the last couple of days. So if you don't hear something or you don't understand something I say, please let me know. I want to make sure that you understand everything. If you need to ask your attorney something, then you may do so. Okay?
Yes, ma'am.
I have read the letter from Ms. Jensen and I have read the letter from Mr. Trenter. And I have heard from both the state as well as your attorney. I also read the victim impact statements that were written, I believe, and what had happened and how it affected them. I don't even know where to start. Because quite honestly, there's some positive things here and there's some negative things here. And how do I weigh that and what do I do? I'm going to tell you in black and white and reading this and the PSI, which has a whole lot of information, and then hearing the argument from the state, it's very compelling to send you to the maximum possible penalty for each of the crimes, which could be consecutive for 10.5 years in prison. And I'd like to say, here's the thing. On one hand, you are a super great dad who does the hunting, who does the gardening, who does the canning, who shows your son how to do positive things and probably work with your hands and fix things because he's very good at that. And then on the other, so be that dad. That's the dad I want you to be. But on the other hand, I have a dad that is sneaky and sly and manipulating and who is teaching his son to do criminal activity, which is really bad. I've had the pleasure of knowing Miss Charles. I'm going to use his first name, knowing Charles, and of knowing Chantel Bentley in depth with all of them. The state does confirm that your story and what happened during the burglaries is most likely what occurred. To me, and in knowing all of the parties in the depth that I know, because I've now learned a whole lot about you, Mr. Evans, and the depth that I know. Chantel was the manipulating instigator, controlling this event and starting it. And then because you were well, as a result of you being under the influence of a substance and under the influence of Chantel, and I'm sure there are multiple ways that she manipulated you, you followed. The worst part of it is that you didn't say, Charles, stay away. He was 17 years old or 16 years old.
17.
Did he just turn 17?
He was 17, yeah.
17 years old, still in high school, in his senior year, and he had to be in jail during that time, or a lot of that time. And then he was thankfully for him, I guess, released on a monitor that monitored everything that he did. Or I believe it was over a year or almost a year. But he graduated. And so that is something that you should be very proud of. And he has goals and he wants to achieve them. Those are the things that you need to help encourage, not criminal activity. Because a father's supposed to protect your children. You're supposed to be the one to guide them, to keep them safe from harm. At that particular time, you were not a great dad.
Yes, ma'am.
It makes a whole lot of sense. hearing about your father and his involvement in the Mexican cartel and your history from your words. I got most of it from this pre-sentence investigation report. Not all of it, but I got most. And the fact of all of the traumatic things that you had to endure during your childhood. Then I can easily see that your dad, again, he had good traits, but he was not a good dad to teach you how to sell drugs and to teach you the crime and to be that person that doesn't respect the law. I agree that you do need treatment and it needs to be in a confined setting. I believe that after release, you need more treatment, probably in another confined setting, such as Farm and Center or Hazleton or something like that. Because I believe both will help you, because we are talking, how old are you?
37.
You're 37 years old. 37 years old. And you have been, if I recall correctly, it was very young. I think younger than 15 when you started using drugs. Correct?
12.
12, yeah, you were very young. So it is ingrained in you. You have to learn how to rip that out and take control of your life and your sobriety. I have 3 recommendations here. One from the Department of Corrections recommending a sentence of either of 5 years in to the max of 7.5 years in, and then 1.5 years in for the other 2, but to have them run concurrent. And then I hear the argument from Mr. Chapman. Makes a pretty good point. Maximum possible penalties with crimes should be the most offensive, the most perhaps violent or aggressive, because there's a spectrum. And you look at this, the low end of 1 year jail or prison to the maximum of 7.5 years. And you look at that individual and you look at their life and what's affected it. You look at their criminal history and where you are with that. You look at you have to think now of a sentence that will, as Mr. Schmidt said, deter you specifically from continuing in criminal activity and conduct, and to generally deter others from engaging in criminal conduct. It has to be harsh enough to do those 2 things. And Charles is part of that general public. I'm hoping upon hope that he has learned and that he understands jail's not fun. I believe on the other case of him selling THC intent to deliver, he had 1 year of jail to sit. And that's a lot for a now 18-year-old to have to sit that much time. My condolences for the loss of your sister.
Thank you.
It sounds like it was a very tragic thing. She was young. She had a whole life ahead of her too. And I know that's going to impact you, and it has impacted you. And you need to talk about this. Hopefully you'll be able to while you're incarcerated. I know your family supports you. Even with the things that you have done, I get these glowing statements, but for the fact if he's under the influence. I'm sorry, I didn't mean to bring up your sister. And I want to make sure that that you're hearing me, and I'm sorry, I should have waited until the end. But I feel for your loss.
It's just another thing that's hard to deal with in here,
I understand. I do. And the reason I did not let you out to go to her funeral, A, is because these are serious felonies. And B, because you've I can't think, absconded. You've absconded on me before. And it was a long time before you were arrested in Buffalo and then came back. I couldn't trust that you would come back. So
I
hopefully
understand.
you can make peace. So these are serious offenses, and especially as we're dealing with burglaries, you never know what could happen. You never know what could go wrong. People could get hurt. The business owners, we've had robberies at night where lights are off and the business owners are just doing their last bits of things or doing whatever, and people break in. That could have caused some serious injuries or death to one who broke in or to the owner. It's a huge risk to everybody. And it's a loss to the victims of all of the property and their safety and their security. And now there's fear and worry and apprehension. And you mix being under the influence of a substance and the increase of the risk, or the risk and the penalty could increase. It could cause more things that you weren't expecting. I've looked at your history. I have looked at your criminal history and where it got more serious and when you finally had your first felony conviction. And in looking at your prison time, I've heard stories of prison. I've heard stories of federal prison, and it depends on the crime that's committed. Is it a blue, or is it some kind of, I would say,
Blue collar
rich person crime versus another person, that there are different levels of federal prisons. Sounds like you were in one of the worst. And I do feel for you, and I believe you with the things that happened. That wasn't enough to deter you from committing more crimes. I understand that you started using substances again, but that's no excuse. Your brain should have went back to what happened in prison. What happened in prison? I don't want to do that anymore. Because, as you said, you could get seriously injured or even die in prison. Very interesting to me when I hear things that have occurred in different prisons. So thank you for sharing. After you were released from prison, you were doing so well. You were on the top of the world at that time. And it was for a significant amount of time. And then you let somebody else's behavior dictate and control and lead you down the other path. I know it was because you were trying to self-medicate. You were trying to feel better, or you were trying to forget all of the things that were happening at that time. But look where it led you. Are you strong enough, Mr. Evans, to take control and really take control of your life?
Yes, ma'am.
I want to see you as a grandpa sitting on a chair, reading to your grandchild. I don't want to see you continuing to be an orange or to have Charles visit his son or daughter through bars or, plexiglass or glass.
Yeah.
And I'm going to tell you, and this is serious, if you do not make the changes you need to make, if you do not gain control of your life, Charles will follow you. He will. And it doesn't matter if he's graduated from some type of school. It doesn't matter if he's had years to learn how to be a plumber. It doesn't matter if he's an apprentice to learn how to cut trees and to do those things. He will follow you if you continue and you go back down the criminal road. I don't want to see that. He's a nice young man, but for the fact that he followed you and Chantel. There are things to be proud of in how you raised him. I want to make sure that you understand I see that.
Thank you.
So looking at the public here, we have to look at the public and we have to look at that deterrence factor. And we have to need to rehabilitate, see that you get some treatment that you need. I just want to make sure that I cover everything, specifically what DOC said. Oh, and the fact that you overdosed, I missed that. You could have died there. I think I covered everything. I think I've said everything that I need to say because this is serious. Everybody acknowledges this. I understand the background, and here we need to look at protecting the public. What the court is going to do as it relates to the I felonies, I'm going to sentence you to 1.5 years of initial confinement, 2 years of extended supervision. They will be concurrent to each other. With regards to the burglary, what I'm going to do is I'm going to sentence you to 5 years of initial confinement with 5 years of extended supervision. And I'm going to allow you to engage in the challenge incarceration program or other earned release programs such as the substance abuse program. However, I'm going to state that you can't engage in the program until you have 2.5 years left to serve. That gives you plenty of time to do the substance abuse programming and to get through that. And it gives the punishment factor and the fact that the court is trying to deter others. You have 574 days of credit as of today, but not counting today.
Correct.
Thank you. I am proud of you, Mr. Evans, for the things that you've been doing in jail and to improve yourself and to improve you as a parent. I see that. Otherwise, I could say no engaging in these programs. I know that you need substance abuse programming. I do. But I'm going to give my spiel about the challenge incarceration program. That's one that I fully back. It is such a great program. And I'm going to tell you, I went and I saw the men and the women who were engaging in that program and how successful they are. It's work, it's hard work. It's harder than the substance abuse programming, but it does different things for your mind and for your soul and for your body. And I was so impressed by the inmates that I saw in that program. With regards to conditions when on extended supervision, the court is going to order that there is absolutely no contact with Chantel Bentley. I'm going to order absolute sobriety, no use or possession of any illegal drugs, substances, or paraphernalia. Regular testing, continued substance abuse programming. Are you going to stay around here?
I don't know. That's to be decided, I guess.
You decided. What I'm going to order is participation, well, apply for and participate in the treatment, Burnett County Treatment Court if your agent, with agent approval, or if the agent decides, okay? I'd love to see you go through that program. It's
Drug-
tough, it's tough,
Drug court?
yeah.
I
Yeah, we changed it
actually,
to treatment court, but yes.
okay, I was actually, I put an application in for that, but I never heard nothing back, so, but
Yeah, we wait until somebody is sentenced to know whether or not we can admit them. But I'm not going to order that that's a necessary thing. But if you want to do it when you're when you're released and on extended supervision, yourself, just tell your agent. I think it would do you good. Gainful employment. I'm going to also order either criminal thinking, either breaking the barriers or thinking for a change, because that could help you as well. Before I go on to the other stuff that I have to state on the record, am I missing any kind of condition that you see, Mr. Schmidt? Oh, no contact with victims or businesses or residents.
I don't think you said restitution.
Oh, thank you. For what? Oh, yes. Oh, sorry. And all of them will be concurrent to each other. The restitution I'm ordering for $13,840.95, joint and severally liable. I'm going to state that the restitution, surcharges, court costs, and fines are to be collected at the percentage that's determined by the Department of Corrections to be reasonable while you are in prison. So I'm not going to order a specific amount right now because they will take, by statute, the DOC gets to decide what percentage they think is appropriate. When you are released from custody, I'm going to order that your payments then be $250 a month. If when you're released and you need time to find a job or you can't go back to Mr. Trenter's employment, then write me a letter so that I know. I will state that your payments will not begin. I'll give you some time. I'll say until 2 months after release. Okay.
thank you, ma'am.
But if you have a significant or substantial financial hardship at any time when you're on extended supervision and you can't afford that amount, you need to write the court so I can have a hearing, so I can go over your debts, what you pay, your bills, and your income. I'm going to tell you that sometimes when people do that, I increase the amount because I'm able to see that there's more money there. Okay. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. I need your DNA. You're going to provide that DNA. You have the ability to request it be expunged, but with this level of a felony, it's not really possible, but you can try. This is a felony, no use or possession of a firearm for life, no voting in any election until your civil rights are restored. Anything else I'm missing, Mr. Chapman?
Not that I can see.
574 days of jail credit. I think that covers everything. Oh, sorry, and costs and fees, thank you. With regards to, it's going to take you a long time to be able to pay that off because it goes to restitution first. I'm just going to do $250, the DNA surcharge for all. That's mandatory and I have to do that. I'm waiving the rest of the court costs and fees. I need you, I want you, so do the victims, to pay that restitution. And I know it's joint and severally liable. And I know that, it should be split 3 ways, but the victims need to be made whole. And there's other recourse that you can do to go after, not that you're going to go after your son probably, but to go after another part of that if you pay it all off. All right, I think that covers everything. Good luck, Mr. Evans. Please take control of your life and take control of what you do. Okay,
Thank you, and I plan on it.
all right, thank you. We are adjourned.
All right, friends, we call it a day there. Thank you for spending your time with me this morning. I hope you enjoyed some pretty good court, I thought. I'll be back tonight, sidebar 8 p.m. Eastern, 5 p.m. Pacific. If you hang tight, as soon as I end the stream, YouTube will send you over there so you can set a reminder. And of course, we'll be back tomorrow morning, 9 a.m. Eastern, 6 a.m. Pacific, a half an hour earlier if you're a channel member. Go have yourselves a great day. We'll see you soon. Take care. God bless.